Dimensioning. Item number 1.
So item number 1, this is my application along with section 5 application for restoration. Matter was dismissed for default in March 2020. My lord, the advocate could not be contacted. My lord, subsequently, my lord, after thorough search, the petitioner has come to know that the concerned advocate, my lord, passed away. During COVID, he has passed away. My lord, thereafter, he tried to contact the learned senior who was appearing. He also passed away in 2024. Thereafter, 24, April 24. Thereafter, my lord, the entire certified copy has been obtained from the department and file traced out. Thereafter, this application has been taken out for restoration. Well, it's an acquisition proceedings under the old Act, Act 2 of 1948. My lord, Land Requisition and Acquisition Act. My lord, the case is that my lord, I could not even serve the state respondent since, my lord, unless I get an order, because unless the current file, my lord, possibly they are not accepting. For today, my lord, I want a direction from your lordship so that I can serve upon the state, my lord, learned government leader, so that they can be, my lord, state can be represented so far as these two applications are concerned, my lord. For today, my lord, this is my prayer.
So we'll see. There is been a delay in filing the application. 2020. You were not there.
No, my lord. That time, my lord, I am the newly engaged advocate. My advocate record is here, my lord. The earlier advocate record passed away in 2020. Learned senior, my lord, Mr. Obijit, my lord, Banerjee, is a famous person of this court, my lord. He also passed away in April 2024, my lord. But subsequently, my lord, certificate copy obtained.
Mr. So and so, learned advocate for the petitioner, seeks to serve copy of this application upon the state respondents. In view of such submissions, let the
GP, man.
Will the copy of this application be served in the office of the government leader?
My lord, kindly fix a date so that I can come back, my lord.
Is this matter after 2 weeks after vacation? Winter vacation. But
Item number 2.
For the petitioner, this is a restoration application. Old brief, my lord, I have displaced the brief. For that, my lord, I need one ticket. Otherwise, if my lateral friend has no objection, then restoration may be allowed.
I never oppose in my life
this is for the first time you will be opposing.
because I did not oppose. The record has to be kept clean.
What happened?
Section 5 application has dismissed on 4th of July 2017.
ये ऑर्डर कब होता है? 4th of July. Yes.
Filed on 9th of August 2017. So it is 100 days lapsed. We should file an application for the
Let my deep be.
Eighth August, 4th July, yes. File an application then. আপনাকে কালকে যে ক্যান থ্রিটাকে বললাম আগে রাখতে প্লিজ স্ক্রিনিং 1 2 3 4 করলেন 1 2 3 করলেন তো আগে তো অ্যাপ্লিকেশনটাকে রিস্টোর করলেন সেটা 3 3 এর পরে 2 2 এর পরে উল্টে গেল মিস্টার Oviru Bhattacharya, an advocate for the petitioner, seeks to seeks accommodation and also undertakes to file an application for condonation of delay. This matter 2 weeks after the winter vacation.
I appear for
You give your sleep, your for state respondents, respond numbers.
1, 2,
In respond number 1, 2,
all respond.
all respond. Next.
Item number 3.
এটা একটা নোট নিচ্ছিলাম ফাইল ছিল আছে 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 ঠিক আছে
Well, on the last location, Mr. Gupta had already placed the entire tax. But I will take your lordship to the incongruities insofar as their affidavit in opposition is concerned, if and when compared to the facts of the case. We will straight away kindly come to paragraph 5, 5D at page 5. 3D at page 5.
So 5
Now,
page
the
5 of page
page
5
5 of the affidavit in opposition filed by my lord the Haldia Development Authority.
yes 5D.
Sir, may I just take your lordship to paragraph 5, 3D? The petitioner company itself changed the mode of requirement by proposing to set up industries in different norms contrary there to their prayer dated 7 September 2001, and the subsequent split of the total allotted land. Well, your lordship may recall it is 1535. For 15 lease deed executed, for 35 we had made advance payment, and they've accepted the advance payment, accept the lease rent too. Now, my lord, and the subsequent split of the total allotted land in the name of different industries are in clear violation of the offer made on 11 September 2001. Now the petitioner comes with a plea that he must be allowed to make payment of the balance 50% at 5.50 per acre as per original offer after lapse of more than 7 years, which is not sustainable in the eyes of law. Well, kindly come to directly to two communications. One, my lord, of February 21, 2002 in the writ petition. That is at page 44 of the writ petition. Well, I believe a list of dates has been handed up to your lordship, subject to your lordship's kind consideration. The lordship may, as a
List of dates, yes.
yes. My lord, your lordship will find the pages in the list of dates itself.
Page 44, yes.
Page 44, may I take your lordship? Revised offer of land. Subject is, this is from the Chief Executive Officer, Haldia Development Authority. Subject, revised offer of land measuring 50 acres for setting up of an aluminum and steel-based industry. With reference to the above, I am enclosing herewith the revised site plan in Mouza, Bhunia, Rayachok, jail number 122, for the above mentioned subject. As regards the allotment of land, the terms and conditions will remain the same. Bid number so and so, 11 September 2001, issued from this office. Further, we acknowledge the receipt of 10 lakhs only deposited by you towards the advance land premium. Along with this, my lord, kindly take the communication at page 46. This is dated July 9, 2002.
Yes.
My lord, this is regarding 15 acres. Kindly take, my lord, the letter. This is again by the Chief Executive Officer, Haldia Development Authority. This is to confirm that 15 acres of land at Bhunia Rayachok, jail number so and so, is allotted to you for the purpose of establishing an export-oriented unit. This is further to inform you that this piece of land measuring 15 acres is part of 15 acres of land offered to you already vide this office letter dated 11 September 2001 and 21st February 2002. So, Malad, this assertion made in the affidavit in opposition is absolutely incorrect and contrary to the records of the case. Now, Millard, kindly come to
In D, what they intend to state in D?
D. In D, paragraph 3D, they stated that this subsequent split of total allotted land in the name of different industries are in clear violation of the offer made on 11 September 2001. When admittedly by writings dated, letters dated February 21, 2002 and my lord July 9, 2002, my lord, it was clearly recorded by the development authority that this splitting up is acknowledged and is also authorized, and in print, and they approved that splitting up of the land because my lord, the infrastructure was never made ready.
Okay. This is splitting up. They say that's the subsequent split of total allotted land in the name of different industries. Why these different industries?
My lord, the one is Manaxia Steel and another is Manaxia.
This Manaxia
Manaxia Steel, one is Manaxia Aluminium. It is not
So-
different industry, my lord.
So Hindustan Seals Limited,
Yes.
this was the allottee. So Manaxia, how Manaxia comes into
Now, my lord,
picture?
Manaxia is the successor in interest.
Okay.
Hindustan Steel was the original allottee. Manaxia is the successor in it.
Okay. This you have stated in
It
your
was renamed. It was renamed. Just
read.
renamed.
Okay. This you have stated in your writ petition?
Yes, my lord, we have stated in our writ petition. Kindly take our writ petition for once.
There is no such dispute with regard to renaming of Hindustan Seals Limited to Manaxia. This is a admitted position.
Right.
So it is not that it has been allotted to different.
Now, my lord, kindly take the allotment letter, the initial allotment letter, which is, my lord, 11th of September 2001
At page.
at page 37.
Yes.
Now, my lord, kindly take the subject of the said letter. It clearly records it is offer of land measuring 50 acres for setting up of an aluminium and steel-based industry. So one part of 50 acres is being used for aluminium plant, another part is used for steel plant. And that too, when it was allotted to Hindustan Seals Limited, which was renamed as Manaxia.
Okay.
and all along they corresponded with us and they approved this splitting up. What I want is that they say in their affidavit in opposition that this splitting up was illegal, but this splitting up was approved by Haldia Development Authority itself, as would be evident from the letter dated February 21, 2002 and my lord July 9, 2002.
Yes.
Along with that, my lord, and that it is authorized and approved would also be evident from the demand raised by them, as would be evident from the letter dated 27 January 2006 at page 59. This is addressed to Manaxia Limited. Despite this office letter as referred above, regarding the above mentioned subject, you failed to deposit the balance land premium till date. You are further requested to deposit the balance land premium amounting to rupees 96,25,000 within 7 days from the date of issue of this letter. Otherwise, the offer may be treated as cancelled. So, my lord, the the price was the premium was fixed at rupees 5.5 5.5 lakh per acre, and the total land area is 50 acres. Out of which, my lord, they received in excess of just 1 minute. They received in excess of 1.2. Now, may I just give that actual figures? The actual figure would be, first, my lord, they received, yes, 1.37, 1 crore 37 lakhs and 50,000.
On 26th March 2002.
My lord, on 27th March 2002,
27th.
my lord, which is at, my lord, para 8, page 45 of the writ petition. My lord, your lordship will kindly take what was the actual payment made. Kindly take page 45.
1,27,000.
1 crore.
1 crore, sorry. 1 crore
My lord,
27.
in addition to the earlier payment of 10 lakhs.
Ah,
And my lord, if we compute 15 acres, 15 acres into 5.50 lakhs per acre would amount to, my lord, about, say, my lord, about 82.50 lakhs. So, my lord, they had already accepted a substantial amount towards advance regarding the balance plot of land. That is 35 acres. Now, what was payable by the petitioner was 96 lakhs 25,000. Well, I will give your lordship the, yes, 96 lakhs 25,000.
no. If it is 50 acres into 5.5, what is the total amount that comes?
5.5, 50 acres, the total amount would be 2.75 crores.
2.75. And
Out of which, my lord, the petitioner has deposited, this is the working, well, out of which, my lord, admittedly, the petitioner has deposited, just deduct 2.75, 96.25 from 2.75. So petitioner has deposited 1 crore 37 lakhs 50,000. Later on, petitioner again deposited 46 lakhs. Just, Mal, kindly give me a second.
yes, yes.
Mal, 46 lakhs. It is 275, right? 275 minus 96, 25. While the petitioner has deposited 1 crore 78 lakh 75,000.
1
The
crore
correct figure.
78 lakhs. So Mujumdar, 1 crore 78 lakhs.
78,75,000 তাই তো দাঁড়াচ্ছে। And my lord, your lordship will find from the letter at page 59 that as on January 27, 2006, a sum of rupees 96 lakhs 25,000 was due.
Page 58.
Page 59. Kindly take the subject. The subject is very relevant. Subject is allotment of land of 50 acres of land for setting up of aluminium and steel based industry. Malad has got that. Now, Millard, kindly take what is the demand as on January 27, 2006. It is 96 lakhs 25,000. In fact, my lord, prior to the filing of the writ petition, we had sent them a check of 96 lakh 25,000, which they did not encash. When after moving the writ court, pursuant to the order passed by this honorable court, we deposited the entire amount. So as per the offer of 5.5 lakhs per acre, nothing today is due and payable by the petition. But this writ petition was filed in 2008. Payment of the entire amount towards my lord the lease premium was made in 2008.
Yes.
And these facts cannot be disputed by anybody. Not only that, my lord, prior to the filing of writ petition, they continued to accept lease rent for the entire 50 acres. Well, I put the question to myself with all humility. Once a landlord accepts rent for entire 50 acres, when there is only a lease deed for 15 acres, it is not gainsaid by the landlord, in this case, my lord, Haldia Development Authority, that, my lord, the lease or the working has been acted upon. And we are paying rent, they are accepting rent. Only when we move the writ petition, then they stopped accepting the rent.
Oh.
And that fact we raised in the affidavit in reply. For that, they filed a supplementary affidavit in opposition, where they acknowledge the fact that yes, they had received rent. They say receipt of rent does not matter.
Just indicate the paragraph.
I am indicating the paragraph straight away. My lord, will kindly take my paragraph 5E.
Yes.
5E, which is at page 7 of the affidavit in reply.
So it's page 5.
Mr. Gupta has done all the work practically, madam. We have just to.
Yes,
Kindly
5B.
take paragraph 5B. May I just read out? It is worth mentioning herein that no lease agreement has yet been executed between the parties in respect of allotment of 50 acres of land. Not possession of the land has yet been formally delivered to the petitioner company. But the respondent number 3 has been realizing the lease rent in respect of the leasehold property of 50 acres of land from the petitioner company. In this context, a copy of the memo bearing number so and so dated 7th March 2007 is issued by the respondent number 3, and the copy of the challan confirming the payment of lease rent of 85,556 are annexed here to and collectively marked as annexure R1. Miller, kindly take annexure R1. Miller, kindly take the date. There is an invoice at page, my lord, 28. 28. My lord, subject is invoice for payment of lease rent land measuring 50 acres.
Yes.
My lordship may kindly note This is after the demand of 96.25 lakhs has been raised in 2006. This is dated 2007. Now, my lord, may I just read it out? This is to inform you that the lease rent in respect of the leasehold land referred to above, so it is 50 acres, is lying due for a period of 1st April 2006 to 31st March 2007, amounting to rupees 85,556. In view of the above, you are requested to deposit the said amount within 21st March 2007 through HDS paying slip available at PNB Haldia. Now, Miller, kindly take the paying slip at page 29. This is the payment made pursuant to the invoice raised by HDA. So for each and every financial year, they had been raising the invoices for payment of rent, and my lord, we had been paying rent.
Yes.
So my lord, these facts cannot be denied. My lord, now, my lord, kindly take their stand regarding this. Kindly take their supplementary affidavit in opposition. So far as the rent issue is concerned, I am concluding that part. Kindly take page 4 of the affidavit in opposition. Yes. Supplementary affidavit in opposition. I'm sorry.
What is the date?
On the supplementary affidavit in opposition, may I give your lordship the date? The date would be, my
1st
lord,
September 2009.
1st September 2009. Yes.
Yep.
Grateful, man. May I just read out paragraph 5?
Yes.
First, they allege that one Pramod Khemka of the petitioner company prayed time to finalize the issue regarding, my lord, this enhanced lease premium, which is again we have denied categorically in our affidavit in reply. But contrary, yes, the petition was filed before this honorable court with an unclean hand. My lord, in the said writ petition, the petitioner did not annex the letter issued by CEO for payment of lease rent measuring 50 acres, which they annexed to the affidavit in reply as annexure R1. Which they annexed in the affidavit in reply as annexure R1 and controverted the same in paragraph 5e in reply to fulfill their wrongful gain. I categorically state that the said notice for payment of lease rent is nothing but a token rent. As per office offer letter dated 11 September 2001, and that does not confer any special right to the petitioner to claim to the effect that the offer letter dated 11 September 2001 are still binding upon the parties and enforceable in the eye of law. So, my lord, admittedly, my lord, lease rent was realized from us. Now, my lord, kindly come back. Kindly come back to, my lord, this page 37 of the writ petition. My 5% of those 75 lakhs. My lord, you'll kindly take on what terms the allotment was. Now,
Yes.
0.25, 0.25, 0.2.
Token rent at the rate 0.25%.
0.75 crores.
Annually. Yes.
My lord, kindly take my lord clause 2. My lord, the land premium, yes, 68 lakhs হবে না 0.25%, 1/4 তো নয় 25% বলছি, 0.25% বলছি, 68,000 হয়ে যাবে। Yes. 500 of my lord, kindly take clause 2. The land premium rate is 5.5 lakhs, that is rupees 5 lakhs per thousand only per acre, and the token rent of 0.25% of the total land premium per year will have to be paid, which will be enhanced at the rate of rupees 5% annually. So 5% of that, subject to the approval of the Board of Haldia Development Office. So your lordship will realize, kindly visualize, for 15 acres of land, alert a sum of rupees 80 in excess of 83,000 was not required to be paid as lease rent. If we compute 0.25% with the 5% increase of that 0.25% quantum, being 0.25% being the principal therein, it will come to, with the passage of years, it will come to yes, 0.25%. It's 68,000, and your lordship, I take your lordship. So, my lord, whatever lease rent was accepted and raised and my lord realized from the petitioner, it pertains to the entire area. And my lord, the challan, which is at my lord page 29 of my affidavit in reply, the challan clearly shows that it is lease rent for the 50 acres. Well, had they been realizing lease rent only for 15 acres, it could not have, my lord, been a figure of in excess of 80,000. So, my lord, they are realizing the lease rent for the entire.
Invoice also says that it is for 50 acres.
Yes. My lord, invoice, kindly take page 29. Not only invoice, my lord, they are
50 acres.
there, but also, my lord, page 28, if your lordship kindly takes.
Twenty-eight
Of the affidavit in reply. This is their, my lord, invoice. Subject itself says, my lord has got that. It's the subject itself says, invoice for payment of lease rent within bracket land measuring 50 acres. And the invoice, and my lord, the challan, which is at page 29. Supplementary affidavit. Just give me actually, I'm just 28, 21. It's a 28 or 21. No, it is okay. Well, kindly give me a second. Paragraph 21. 18 years, September. Oh, it's a reaffirm, bolo na? 2020. Same paragraph. এটা রিয়াফার্ম হয়েছিল কি এফিডেভিটটা? আছে because the records were not traceable.
Yes.
Reaffirmed according to the present format, because now the format is, my lord, line spacing is now 1.5, and my lord, it is A4. মাত্রা ওইটা বলে দিচ্ছি আপনাকে, প্যারাগ্রাফ সেম আছে। As per the current, my lord, the affidavit in opposition reply, it will be 20 is for, my lord.
Invoice and 21 is the challan.
Thank you. Grateful, my lord. I'm grateful. I'm sorry, my lord. Well, I'm grateful to my learned friend. I'm extremely sorry. So, my lord, this is my submission with regard to the acceptance of lease rent for the entire. Now, my lord, now they also raise a frivolous issue regarding, my lord, making allegations against one Khemka. This is at paragraph 3H of the affidavit in opposition, which is at page 9.
Yes.
It is alleged that this Khemka is further, because these submissions would be made. So it is my duty to point out to your lordship what allegations have been made against us and how have we dealt with them. It is further pointed out to a point. It is further pointed to note that after receiving the letter dated 4th January 2008, one Pramod Khemka, the representative of the petitioner company, had met the CEO of HDA, and a discussion held between them in the presence of other officers of both parties. Mr. Khemka proposed to adjust the amount of rupees 96 lakhs 25,000 at the old rate of 55.5 lakhs per acre, and the remaining land to be paid at the present rate of 15 lakhs per acre. And ultimately, he prayed for time to finalize the issue. So there was no commitment at all made. Finalize issue within a short period of time after discussion with his company management. Now, we have denied that at paragraph 8 of the affidavit in reply. There is a categorical denial at paragraph 8. So far as the allegations made against the petitioner referring to the discussion held with Mr. Khemka. Maharaj has got that, paragraph 8. Now, kindly come to paragraph 3I of the affidavit in opposition.
Three.
I. Page 9. Starts at page 9 of the affidavit in opposition.
Yes.
The petition, may I take your lordship through that? The petitioner company repeatedly harped about the so-called commitment made by HDA, but the petitioner never put forwarded any iota of ground which might prove its claim, as it appears from the letter by Chief Engineer Commercial WACB in his memo dated 16 July 2002 addressed to Hindustan Seals, whereupon the petitioner was requested to pay 30,000 for bulk power supply at 33 kV from WBACB. Pursuant to the said letter, the company deposited the said amount very promptly on 18 July 2002. As aforesaid, it is evidently proved and also admitted fact that there is no commitment or promise by HDA to supply power to the doorstep of the company, in spite of no commitment by the HDA to the petitioner. Just to facilitate industrial growth and to provide infrastructure, HDA allotted 7.5 acres of land absolutely free of cost to WBACB, at present WBACTCL, adjacent to the petitioner company, to provide the power in the said industrial zone, which was in fact in said industrial zone. So it is not, my lord, an arrangement just to, my lord, cater to the need of the petitioner. They very tactfully use the expression in the industrial zone, which was in fact acted upon the decision of the board, and it is admitted fact that the petitioner company had got power on August 2006. In spite of that, the petitioner company did not take any initiative to make payment of balance payment, even though they committed to make payment from April 2006. So, my lord, the facts which emerge from this paragraph, from 2002, 2001 end to 2002 to 2006, there was no power supply. Now, Miller, their stand that they did not make any commitment is contrary to this resolution of taken by them in the 71st board meeting. Kindly take the 71st board meeting, page 40 of the writ petition. Eight. This is the 71st board meeting, 8.
Yes.
My lord, if 71.2535 II, this is the, my lord, the item. My lord,
This resolution was taken after you approached them for
yes,
decreasing the
reduction.
land premium. They said that since we have to
We are
provide the,
providing infrastructure,
so we
will not.
cannot reduce the land premium. This
And
you
my
are
lord, in that resolution, they say that they will take steps for providing power to the petitioner company. And also kindly take note of the 73rd resolution, board resolution, page 47.
national track committed to gain approach in Calcutta from water university of page 48.
Paragraph 73rd board meeting, the resolution number 73.06, right? 73.06. At the top of page 48, where they resolved that, my lord, the infrastructure will be made ready and made available to the prospective industries.
Yes.
Kindly take the 75th board meeting. Next page, which starts at page 49. Kindly take, my lord, page 50. At the bottom of page 50, which is 78, 75.06.
Yes. Generation. Okay.
My lord, kindly take in the 74th meeting of the board held on 11th June 2002, it is resolved that HDA shall provide water and assist in getting power up to the premises of each industrial units. Hindustan Seals have started construction in their allotted plot beyond MCPI factory, close to the bank of River Hooghly. Letter dated August 1, 2002 is enclosed. In this industrial zone 2, an array of industrial units are expected to come. In view of this, it is necessary to start acting on development of necessary infrastructure in this zone, to start with a 132 kV substation along with associated lines, and a network of industrial water supply line has to be planned. If approved in principle, HDA shall initiate action for fulfillment of this requirement. So, my lord, till this is, my lord, this resolution of 2002. Whereas in the paragraph 5.3.3i, upon perusal of the amendments made therein, it would be apparent that the power supply could only be effected, that too at the initiative of the petitioner company, not, my lord, HDA, could only be made available to the petitioner company in 2006. And
Was there any letter issued by the HDA informing the petitioner to take over the possession of 35 acres of the balance land?
my lord, permissive position, kindly take one. My lord, kindly give me a second.
That letter, last time you shown me the letter. Mr. Gupta, last time you showed a resolution, but later,
Page 37, if your lordship kindly.
Possibly what is from 37 clause.
no, you submitted on the last day that you have also made construction over the balance land.
Yes, yes, yes.
And it was also admitted by the HD that possession of that land,
Functional unit.
the possession of the land has been handed over of the balance amount.
And the possession of the land,
Where is that?
kindly give me a second. Matlab, to the best of our information, matlab, it is my duty to point out, matlab, there is perhaps no formal letter of handing of possession. So far as
Okay.
the balance, 15 acres, matlab, obviously lease executed. Matlab, matlab, that is a fact. Matlab, what is the fact, matlab, we have to state it before. But the fact remains that, matlab, the functional unit is one of the highest revenue earning industry in West Bengal right now. Running into, matlab, the turnover is in excess of, matlab, few hundred crores. Few hundred crores. That is that. এটা তো বান্ধবী।
এটা তো কোথায় গেল?
In fact, my lord, the amount which has been paid by the petitioner from 2009 to the union and state exchequer towards revenue collection is in excess of 630 crores. If they want to lose this industry, so be it, my lord. We will go elsewhere, somewhere elsewhere.
Okay.
Yes, that service tax. Yes.
Okay.
So this is the fact. Matlab, whatever is there on record, I will not make any submission contrary to it. Now, my lord, coming back to the affidavit in reply. My lord, though no letter of position has been given, but they are realizing the lease rent.
Yes.
That's a fact. That is an undisputed position of fact. On the lease rent is taken from me. It can only be taken from me after delivery of possession, not prior there.
Yes.
So, my lord, this is the kind of, my lord, deemed position. By reason of the fact that they started realizing rent from us for the entire land. Now, your lordship, I take your lordship back to, my lord, apropos what has fallen from my lord. Kindly take your lordship. Kindly takes, my lord, this payment of rent clause, clause 2. Now, obviously, my lord, the payment of rent and realization of rent could only happen, my lord, subsequent to the delivery of possession and enjoyment of the property by the lessee.
Possession land.
I mean, now kindly may I take your lordship back to, there is another allegation made in the affidavit that the petitioner has constructed a residential complex. So that is at page 20, paragraph 20 of the affidavit in opposition, which we have denied at paragraph 17 of the affidavit in reply.
Yes.
Rent का तो नीचे तो नीचे once they accept the rent they does not arise. Similar now coming back to this residential complex issue. Paragraph 20, I pointed out to your lordship that is affidavit in opposition, and paragraph 17 of the affidavit in reply, where my lord, I have clearly denied the said allegation regarding construction of residential complex. Without in their affidavit in supplementary affidavit in opposition, they refer to one instance where they enhance the fees premium in respect of one company. I mean, kindly take page 10 of the affidavit in supplementary affidavit in opposition. I mean, kindly take the date
Wait, let me find out.
at supplementary affidavit in opposition. Go ahead. Page 10, 2nd August 2006. This is at page 10 of the affidavit in supplement. My lord has got that. I'm sorry, yes. Well, actually,
Yeah.
there are now 3 sets of affidavits.
এগুলো ভালো হতো একটু ওনাকে দাও না জাস্ট ফাইন্ড ইট আউট
I
ফর
will
মি
I'm so sorry, my lord. I referred to this supplementary affidavit in opposition while dealing with the rent issue.
yes
My lord, should be, my lord, at the time of conclusion of hearing, should we make a, my lord, a kind of spiral containing all the pleading?
yes
My lord, I think that will be helpful and subject to verification by my learned. Only I think that will be helpful for the party.
okay
Convenience compilation, we will prepare that. এটা হলে তাহলে সুবিধা হবে দর্শক। So, my lord, now, if I take your lordship to page 10 of the affidavit in opposition, supplementary affidavit in opposition, I'm sorry,
yes
they refer to allotment of land for the proposed industrial project at Holdia.
Yes.
Now, my lord, kindly take the date. This 17 February 2006. This is in reference to the visit of our Mr. S.N. Kaur and the discussion he had with your official on 1/8/2006 at Holdia. It is understood that you have taken a decision for confirming us the allotment of, so it is not at the stage of post allotment of land. This is, my lord, a decision taken for enhancing the lease premium prior to the allotment of land.
yes
This is not a case, a post allotment enhancement. This is a pre allotment enhancement. So, at the stage of pre allotment enhancement, it's a question of an offer, invitation, invitation to offer an acceptance. At that stage, my lord, it is like this, my lord, take it or leave it. I will allot you a land only at 17.25 lakhs per acre. If you are ready, we will allot you, otherwise we won't. But in our case, this is factually clearly distinguishable. Allotment was made and the enhancement was after 7 years and they failed to provide the necessary infrastructure. And that then they stepped in and decided to terminate the allotment. So, my lord, kindly take, this is the commitment made by Chandra Chemicals. And kindly take the resolution. This is page 12 by GD. Allotment of land to Messrs. Chandra Chemical Enterprises.
Hmm.
On request, HDA on 17th April 1996 allotted 10 acres of land to Messrs. Chandra Chemical Enterprises. Kindly note the date 96 for an industrial project at Holdia as per usual terms and conditions at that time. Messrs. Chandra Chemical Enterprises had deposited 50% of total land premium on September 96. After that, HDA informed Messrs. Chandra Chemical to deposit the balance land premium and take possession of the said land and start the construction work. Recently, Messrs. Chandra Chemical, this is after 10 years, they come, Chandra Chemical Enterprises informed HDA that they are willing to start the work and by depositing the balance land premium as per previous rate. However, HDA rejected their proposal and informed them to deposit the land premium as per new rate. Recently, Chandra Chemical Enterprises submitted a proposal in its letter dated 2nd August 2006 that 50% of the total land premium deposited by them be considered as full payment for 5 acres of land, and for the balance 5 acres of land, the land premium would be as per new rate. Messrs. Chandra Chemical Enterprises also informed that they desire to set up one downstream project within its 10 acres of land and in the name of Chandra Chemical Enterprises, sister concern of Chandra Chemical Enterprises Private Limited. So kindly compare the facts of Chandra Chemical Enterprises and the facts of the case in hand. But in this case, for 15 acres, indisputably payment made. Total allotment is of 50 acres. For 15 acres, payment made, lease deed executed. For balance 35 acres, a sum in excess of, it will be, my lord, 82.5, 170, কত হলো? না, 170, কত হলো না? More than 1 crore has been deposited long back in, my lord, 2002. Indisputable. My lord, the petitioner has constructed factory, carrying on its work. Infrastructure as promised never provided to the petitioner. The petitioner 127 plus আরো আছে। না আরো আছে, আরো 46 আছে। বুঝেছিস তো? আরো 46.25 lakhs আছে, which takes us to 170. My lord, in this case, what has happened? We have deposited this premium for 15 acres allotted, this deed granted. For balance, we have paid in excess of, my lord, about, my lord, 96 lakhs. 96.25 lakhs we have paid. The balance 96.25 lakhs is, my lord, payable. Kindly take, my lord, so, and we have constructed. It's not that we did not start our work. We started our work and, my lord, we made payment and they also charged this rent. So these facts, the facts in hand, of the case in hand, are not akin to the facts in the case of Chandra Chemical Enterprises. And they cite it as an illustration that, look, so since we have adopted this procedure, in case of Chandra Chemical Enterprises, there is no discrimination. The apparent discrimination, even if assuming, The apparent discrimination is like this, my lord. If you take their resolution, they have paid, my lord, 50% in Chandra, for which, my lord, they were given a waiver of the enhanced rate for the 50% of the land, that is 5 acres, 10 acres was their total. In my case, what they do, though they have accepted 50% of the premium for the balance 35 acres, they say you pay for the balance 35 acres at the enhanced rate for the entirety of 35 acres.
As if this is a separate lease.
As if now, my lord, we have concluded on the facts, my lord. Only the judgment. And I believe, my lord, your lordship. My lord, quickly may I run through the judgments? My lord, these alternative remedy, because obviously they will take the point of alternative remedy. Now, my lord, kindly take the first judgment. 2005 6 SCC 499, paragraph 23. Now, before that, my lord, kindly take, my lord, 1970 volume 2 SCC, page 355. ওটা আছে? Yes. This is, my lord, L. Hriday Narayan, paragraph 13. The order under section 35 of the Income Tax Act is not appealable. It is true that a petition to revise the order could be moved before the Commissioner of Income Tax. But Hriday Narayan moved a petition in the High Court of Allahabad, and the High Court entertained that petition. If the High Court had not entertained this petition, Hriday Narayan could have moved the Commissioner in revision. Because at the date on which the petition was moved, the period prescribed by 33A had not expired. We are unable to hold that because a revision application could have been moved for an order correcting the order of income tax officer under 35 was not moved, the High Court would be justified in dismissing as not maintainable the petition which was entertained and was heard on merits. Well, in this case, the petition was entertained in 2008, interim order was passed, payment was made in terms of the interim order, and they accepted the payment. No challenge to it. So it is too late in the day to contend that alternative remedy of, my lord, civil remedy would operate as a bar. Next one, my lord. This is now 2005 6 SCC 499. Now, my lord, your lordship will find kindly take paragraph 23, continuation of paragraph 23 at page 518 of the reports. It was stated, it was noted by this court. My lord has got that page, paragraph 23. My lord, continuation is at page 518. It was noted by this court in L. Hriday Narayan versus ITO that if the High Court had entertained the petition, despite availability of alternative remedy and heard the parties on merits, it would be ordinarily unjustifiable for the High Court to dismiss the said on the ground of non-exhaustion of statutory remedies, unless the High Court finds that factual disputes are involved and it would not be desirable to deal with them in a writ petition. Now, the facts are made known to your lordship. Now, the next one is, my lord, 66 ELT 574. Paragraph 14 to 16. This is opposite to the facts of the case. Kindly take from paragraph 14 to 16. Apart from this, my lord has got that. I'm sorry.
Yes.
I should have waited. Apart from this, courts have repeatedly held that the availability of an alternative remedy does not affect the jurisdiction of court under Article 226, but is a fetter imposed by courts on themselves. Ultimately, it is a question of the court's discretion. The Supreme Court in the case of Rida Narayan has held that once an application under 226 has been entertained and affidavits have been filed, it would not be a proper exercise of judicial discretion to relegate the petitioner to the remedy available under the statute. In this case, the writ petition application has not only been entertained by court, but an interim order was passed on 26/5/1992 directing the respondents to allow clearance of the goods by the petitioner at the old rate. Just like our case that we were directed to make payment of 96.25 lakhs, which is as per the old rate of 5.5 lakhs per acre. Directions were also for filing of affidavits. The order was passed after hearing the submissions of the respondents. It is emphasized by the respondents that they had taken the point of alternative remedy at the earliest possible opportunity. Clearly, then the learned judge who passed the order on 26 May 1992 had negatived the submission and had considered that the writ application should be entertained and heard by the court in its jurisdiction under Article 226 of the Constitution. There is no reason, therefore, particularly at this stage, to refuse to entertain the petition. The next judgment would be, my lord, 204 ITR 276. Ache? No. My lord, kindly take page 282 of the reports.
Paragraph?
My lord, it's not paragraph, my lord. It is all placitum. But it is
Okay.
old ITR, my lord. They did not have that paragraphs, my lord. But my lordship may kindly take page 282, placitum B. My lord has got that.
Yes, yes.
See, the writ petition, this was the issue raised before the High Court at the stage of final hearing. The writ petition should not be entertained as the petitioners had an alternative remedy available under the Act. I will kindly take the answer to this question. I will kindly take page 284, the last paragraph.
Yes.
For all these reasons, respond. Is it a marked copy, my lord? I put the question to myself. Is it a marked copy which has been handed?
Mark which has been made a photocopy.
Well, we'll get a fresh copy only for
Okay.
perusal of your lordship. My lord, we are
Okay.
just for the perusal. My lord, we will give your lordship a
No, no.
fresh copy. For all these reasons, the respond number 1 which could not have been assessed the share of Robindranath Mukherjee in the estate of Sri R.N. Mukherjee in the hands of Mohammed the petitioner. There is no question of the court not entertaining the writ petition as contended by the respondents. The court has already entertained the petition, issued a rule nisi and interim order. Affidavits have been filed and the matter heard at length. It is well established that the court would not, in the circumstances, be justified in rejecting the petition on the ground of alternative remedy. So, my lord, in this case also, my lord, affidavits filed, interim order granted, and we have acted on the basis of this. My lord, now, my lord, what the next proposition of law which I want to canvass before lordship is that when state within the meaning of Article 12 is the landlord, how they are supposed to act. Now, my lord, for that proposition, my lord, kindly take first 2004 PSCC 214. It had a copy data. 214, paragraph 1819.
Yes.
My lord has got 1819. May I just take your lordship to paragraph 18? In our opinion, in the field of contract, the state and its instrumentalities ought to so design their activities as would ensure fair competition and non-discrimination. They can augment their resources, but the object should be to serve public cause and to do public good by resorting to fair and reasonable methods. The state and its instrumentalities as landlords have the liberty of revising the rates of rent so as to compensate themselves against the loss caused by inflationary tendencies. They can and rather must also save themselves from negative balances caused by the cost of maintenance, payment of taxes, and cost of administration. The state, as the landlord, need not necessarily be a benevolent and good charitable Samaritan. The felt need for expanding or stimulating its own activities and other activities in the public interest having once risen. The state need not hold its hands from seeking eviction of its lessees. However, the state cannot be seen to be indulging in rack renting, profiteering, and indulging in whimsical and unreasonable evictions or bargains. And this was a writ petition, my lord. A balance has to be struck between the two extremes. Having exempted from the operation, this was the exempted from the operation of rent control legislation, the courts cannot hold them tied to the same shackles from which the state and its instrumentalities have been freed by the legislation in their wisdom, and thereby requiring them to be ruled directly or indirectly by or by analogy by the same law from which they are exempt. Otherwise, it would tantamount to defeating the exemption clause consciously enacted by the legislature. At the same time, liberty given to the state and its instrumentalities by the statute enacted under the Constitution does not exempt them from honoring the Constitution itself. They continue to be ruled by Article 14. The validity of their actions in the field of landlord-tenant relationship is available to be tested not under the land rent control legislation but under the Constitution. The rent control legislation, this is so beautifully laid down, my lord. The rent control legislations are temporary, if not seasonal. The Constitution is permanent and an all-time law.
Yes.
My lord, now the last judgment which I seek to rely on is Bharat Petroleum versus Madullah Ratnavali. একটা জজ সাহেব, এটা কি এটাই দিয়ে দিই। Paragraph 16. May I take your lordship to paragraph 16? An executive action must be informed by reason. An unfair executive action can only survive for a potent reason. An action which is simply unfair or unreasonable would not be sustained. Objective satisfaction must be the basis for an executive action. Even subjective satisfaction on the part of the state is liable to judicial review. The state, whether acting as landlord or a tenant, is required to act bona fide and not arbitrarily, when the same is likely to affect prejudicially the rights of others. Then, my lord, kindly take paragraph 25. My lord has got that?
Yes.
This court number of times has laid emphasis on reasonable action on the part of the state, even as landlord. Sri Dwarkadas Marfatia in contractual matters, Noble Resources, State of versus State of Odisha, State of Karnataka versus All India Manufacturers Organization. In fact, my lord, Dwarkadas Marfatia was also relied on by the Supreme Court in the judgment which I cited just prior to this, in my lord Jamshed Hormuzji Wadia. Then paragraph 26, reasonableness and non-arbitrariness are hallmarks of an action by the state. Judged from any angle, the action on the part of the appellant does not satisfy the test of fairness or unreasonableness. It being wholly arbitrary cannot be sustained. This is the law which has been laid down by the Supreme Court. May I just summarize? First, my lord, allotment has been made for a total land of 50 acres. For 15 acres, well, splitting up of the land into 15 and 35 was approved by HDA, contrary to their stand in the affidavit in opposition. For 15 acres, my lord, the payment of lease premium made. lease deed executed. The dispute is regarding 35 acres, balance 35 acres. The fact remains that for balance 35 acres, they had accepted 50% of the land premium. Long back in 2002, 2003, 4. From the very inception, they are charging lease rent for the entire 50 acre. Lease rent is not limited to 15 acres. In fact, my lord, when a prayer was made for reduction of lease premium, that prayer was turned down, that the HDA would provide the necessary infrastructure, including water, power, and roads. My lord, it is a matter of fact that the infrastructure was not made available to the petitioner. A contrary stand contrary to the records has been taken by the HDA that they were not they did not make any commitment. Contrary to the resolutions taken in the 71st board meeting, 73rd board meeting, 74th board meeting, and 75th board meeting. Next. Now, my lord, in 2008, they issued the impugn notices. First notice in January and the next notice in the month of July, right? Month of July, 4th July, 4th June. These two notices are the subject matter of challenge before your lordship. The petitioner offered to make payment of 96.25 lakhs, that is 50%, that is the balance amount for the rest of the land. Prior to moving the same payment was not accepted. The petitioner moved the writ petition. Direction was given by this honorable court that you make payment of this 96.25 lakhs. And payment was made by the petitioner, accepted by the respondent. The said interim order for last, I think, last how many years? Last 16 years has not been challenged before this honorable court by way of an intra-court appeal. It is too late in the day, at the stage of final hearing of the writ petition, to contend for the HDA to contend that alternative remedy would operate as a bar and the petitioner should be relegated to civil remedies. Once the affidavits are exchanged, payment has been accepted. Well, it is in view of the judgments delivered by this honorable court and the honorable Supreme Court. Well, it is now accepted. It is not a settled proposition of law that under these circumstances, alternative remedy would not operate as a bar. Then, my lord, comes to the role of the state. And HDA is a state within the meaning of Article 12. Role of an entity, in this case HDA being an entity under Article 12 entity, as an landlord. The Supreme Court has deprecated the practice of any state entity under Article 12 when acting as a landlord to indulge in practices like rack renting, profiteering, and taking steps for unreasonable and harsh evictions. The law has been settled with Jamshed Hormuzji Wadia, as well as, my lord, the later case of EPCL. Here just handled EPCL versus Ratnavali something. So, my lord, sum up, having regard to the facts of the case, once the entire payment has been made, once it is demonstrated before your lordship that they had accepted the lease rent for years together till, my lord, 2008. Well, it is not gainsaid by the petitioner, by the respondent HDA, that we did not give you possession formally. If you did not give me possession, you should not have charged me rent for that particular. Admittedly, the charge rent for the entire 50 acres, and admittedly, I paid the rent for entire 50 acres. Well, the formality of handing over possession, minuscule irregularity is cured by the fact that they have been charging rent.
Mr. Maiti, last time you admitted on behalf of HDA that the possession has been delivered. Yes.
These are my respectful submissions with your law. So
Okay.
once Mr. Both and let him make submission, my I reserve my right to give reply if necessary.
Okay.
I take your law.
Yes. Okay. Okay, এইটা দিয়ে দিন ওর একটা ইয়ে দিয়ে দিন। Mr. Gupta, I'm giving you this copy. You give a fresh copy of this.
In course of the day, we shall hand it to her.
Okay. And just indicate in Hriday Narayan which paragraph Mr. Mujumdar has. Give the paragraph number. Is it 6? Yes. Sir.
Para
What?
30.
6. Okay. But Mr. Obrotosh Mojumdar, learned senior advocate for the petitioner, who concludes his argument. Mr. Sholil Kumar Maiti, learned advocate for respondent number 2 and 3, Holdia Development Authority, seeks accommodation to place his points of argument. Okay. आपको 18 तक ये आ जाए 18 December.
Could it be any day? Yes.
Item number 4.
Lord, item number 4, I have a petition. Item 4, I have a petition. Lordship, I'm saying that the matter we kept after the vacation, Lordship, was the advocate on notice. Was the advocate of records. The sister is going through chemotherapy. Lordship, the affidavit in reply is already affirmed.
Who is for the state?
Lordship, on the last day,
Opposition on reaffirmation. They have given you a copy.
Lordship, the copy is present with us, but it is not present on record. That is why on the last date, Lordship had
And
directed.
have they given a reaffirmed affidavit? Of no.
But the affidavit in a reply is already found. I have a copy.
None appears on behalf of the state respondents. Mr. So learned advocate for the petitioner, seeks accommodation. Is this matter 2 weeks after the Sindhu Shop report? নোট করা যায় 2 and 3 কি বলেছে লাস্ট পার্টে 2 and 3 তো দেখে নেবেন তো ফার্স্ট মনে হচ্ছে এই যে আছে ভুল করে দিয়েছি নেক্সট
2 weeks after.
Item number 5.
Item number 5, petitioner is being represented by learned counsel Mr. Rohil Islam. He is not present today. Accommodate us. There is a similar matter which is appearing on minor section 19th of December. If Madam is fine enough to put them.
On the prayer of learned advocate for the petitioner, release this man, opponent in none appears for the state. Release this matter 19th. 19th.
Right.
Item number 6.
Starts with copy of the AO and AR upon which.
And the primary state respondents have a copy of the affidavit. There is a copy of
From the state respondent, and that has been served by the petitioner. But from petitioner side, the AR, that is the evidence reply, that has not been served upon me.
state has given you a copy of the opposition.
From state petitioner gave me this copy of the opposition.
Okay. There is a copy of the affidavit of opposition. There is a copy of the affidavit in reply.
That's
Wait,
matter for final.
there is a copy of affidavit in reply to such affidavit in opposition. Copy of the reply has been given.
No, my lord, reply has not been given, opposition has been given. It has been filed by the state respondent. That I have collected by itself from the petitioner side.
But the petitioner was directed to give you a copy of the reply.
Yes, that is not done. His reply copy has never been served up.
Okay, none appears on behalf of the petitioner. The state is also unrepresented. Learned advocate for the private respondents submits that though the copy of the affidavit in opposition has been served upon him by the learned advocate for the petitioner, but ask him to come. Ask him. Ask him.
Item number 7.
Okay, I am for the petitioner. Kindly go through the last order.
An appeal against state respondent not in affidavit 5. Petitioner. Where is the letter of intimation?
I have got the land.
The
Why not one submission? Matter can be revised.
without what is the matter?
Matter is that petitioner husband lifetime filed an application for a long term finding. That was not considered, and subsequently petitioner husband made an application before the Honorable High Court, and High Court passed the order directing the discrimination by other. He was since 2000. All of a sudden they stopped the order of without any.
Being heard, the learned advocate appeal for the received parties and concerned the facts and circumstances of this case, I disclose the defendant right now
Now, without finding any.
Huh?
Then petitioner husband filed another application before the High Court, being WP number 13782 of
That was disposed of directly the.
What was the direction in the first writ petition? Meanwhile, there will be an interim order. The FA application shall be at
After
liberty.
that,
Sent to the river bay. It shall once again. Utilize of the extraction and service. Rules.
you have noted that Mr. of the order, the last. Order dated
By directing consider dispose the application and petition for grant of. What happened thereafter?
thereafter, as per the order in the petition number 16782 of 2016. Respondents were directed to
No, what was the order passed after 24th December 2001?
December 1. That petitioner made an application thereafter.
What is the order passed?
Order was passed. Directly reported that the
What is the order passed after hearing?
after hearing, they rejected the application.
Where is that?
Thereof. Page number 99 upper main portion, and it is starting from page number 95. Order dated 18th October 2022.
Please only consider dispose of despite not. Okay. What is the legality in the order? What is the legality in the order?
My lord, I'm coming to the point that I'm reading the order of the 97. However, sorry, 98 last paragraph onward. I'm reading. Records further reveal that the petitioner has submitted an application Dimension 496 for granting sand mining lease in respect of area 10 acres situated at the river bed of Ajay on plot number 12 1212 in Moja Palitpur under PS Nanu before mining officer in charge civil region under the provision of West Bengal Minor Mineral Rules 1973. It further reveals that appears that the mining officer in charge civil region after receipt of the trade application by his memo so and so forwarded the same along with a feasibility report to DLR. Madam, kindly just see the feasibility report. Point 4 in the feasibility report submitted by mining officer in charge civil region revealed that a bridge was being constructed on the south northeast side of the applied area and therefore a part of the state applied area was situated within 200 meters from the said bridge. After receipt of the said feasibility with the district land and reform officer, with whom I memo number memo dated 2nd November 1919 has forwarded the ability report on the petitioner mining lease application dated 17/4/96 to the director of mines and mineral Adjournment with observation interior that area after mining lease was situated within 200 meters from the under constructed river tree and Pakka road and therefore the DLRO did not recommend the said mining application on the petitioner. Minor, this report was report was filed on 2nd November 1999 and petitioner application is 1996 and High Court's interim order was 2001. My lord, kindly note this. Record further reveals that state government in the Commerce and Industry Department by order dated 240-CI stroke D stroke CN dash 233 stroke 99 dated 12 March 2021. This is before passing the order of High Court order. My kindly note down. Had rejected the aforesaid mining application dated 17/4/96 of the application is take in terms of Rule 8 of the West Bengal Minor Minerals 1970 in view of the report from the observation of that DLR report. Now, my submission is that when the petition 19162 W of 2002 was heard, state advocates for statement respondents were available. That time, this report was not revealed, which was passed before this one. That 2000 at 12 March 2021, passed by the Joint Secretary, Commerce and Industry Department of Government of West Bengal. Thereafter, petitioner was extended sent up to 2014. Suddenly, test stop without any reason, showing any reason. Petitioner made several visits to the office. Thereafter, with finding no alternative, he filed another application, 16772 and 16782 of 2016. And that time, when it was heard, on several occasions, till final order, none stated about the said order, which was passed before this order passing of High Court to directing, giving liberty to the petitioner to extract sand from the land in question. Now, in the meanwhile, petitioner husband died, substitution filed for substituting her widow. That was granted. None expressed the view that it is already petitioner application has been rejected. Thereafter, as per direction of the Honorable Court, petitioner wife was substituted was heard in case of learned advocate. It is
You have,
for the
where is the document that you have extracted the sand and paid royalty?
My lord, this is in the sorry,
You see that till 14 you have extracted sand.
my lord, page on 40 onward.
40.
Till annexure P3, my lord, and 39 onward. Till page number, up page number 49. No, sorry, 48.
Thousand 10. So yeah, because it's authentic lecture. Who appeared for the state in this matter?
Mr. Chandikan, currently. My lord, one more submission. If at all this integrity report was the hindrance of the of extracting sand from the land in question, then how petitioner by the order of the Honorable High Court was extracting sand up to 2010? And as per my as per petitioner,
Uh.
that bridge is not at all in the hindrance for the extracting, and it was away from at least 400 meters from the place from where the land is being extracted. Now the land is without any trees, and
Ashwin.
now that report is either manipulated or by intentionally or to harass the police.
Mr. Swensu. Acha. Pursuant to order of this court, notice has been served upon Mr. Chundi Charan De, done it, additional government. To file your report. Here is a case where in the year 2002 an order was passed for considering the representation of the petitioner and also directing, giving liberty to the petitioner to extract sand, and the state shall raise the royalty. He continued, just a minute. The petitioner, husband of the petitioner, continued to extract sand and he has also paid the royalty. Now this has been cancelled, saying that it is within the 200 meters, which is violative of Rule 8 of the Miners and Minerals rules. Within 200 meters, you cannot extract sand. But the petitioner's case is that her husband continued to extract sand till 2014. This was never brought to the notice of the court. This is his grievance. A feasibility report has been depicted in the order of the state authorities. The state was asked to file an affidavit in opposition to that, annexing all the documents that how this extraction was continued or why this matter was not brought to the notice of the court that this particular land is within the 200 meters of the bridge. What is that bridge? What is the name of that bridge?
Bridge with no name, only bridge.
Only bridge. So what is your submission? I'll make it not today, or it will be coming. Ask him to come. Ask him to come. Pass over. Ask him to come.
Just with order. This
So, দিয়ে দাও
order
এখন
is-
দিয়ে দাও। দিয়ে-
That deviation order, my lord, now they are
Wait, let him come, let him come. Yes,
Item number 6.
6.
Item number 6.
I am for the petitioner. It's of the state authority that land is acquired in accordance with law before the Second World War against the Burma.
Prior to that, one of the clients, those order of.
Give a copy of the reply you have not given.
Yes, I have given reply, my lord.
Officially given to me by.
Ah. You have filed your opposition.
I have not filed my opposition because affidavit in opposition has been filed by the state.
You will
I am
affirm.
relying upon that.
Okay. You give a copy. Copy of the reply.
Six or small, 6 or.
And my lord, fix next week, my lord, then I can.
चलो पास पास की बोल रहे देख ঠিক আছে আসো নেক্সট ডাউট
Item number 8.
May I please, your lordship? I am for the petitioner, my lord, in this matter, my lord. The daughter is the petitioner of your lordship. The property originally belongs to one Bhakti Pada. He died leaving behind with Bhakti Pada Chattopadhyay, leaving behind 2 sons and 1 daughter. Plot of land, my lord, lying tag number 1523.
two sons and 3 daughters
1 daughter.
one daughter
2 daughters, my lord. I will wait with that, my lord.
2 or 3
Madhavi and
Ashi is Dev and who are the petitioners
she's the
Nilima and Madhavi
Nilima Madhavi. They are the
these are the
petitioners
2
of your lordship.
daughters and respondent numbers 7 and 8 are the sons
They are the sons.
then 4
4. The plot of land is subject matter of dispute is 1523.
Ah.
Now, this is subject matter of acquisition under the National Highways Act. As I did not get or receive any compensation from the authority concerned, we made a representation. The authority that your lordship find page 21. We came to know that the entire compensation money was been utilized or been paid to the respondent number 7 and 8. In the legal heirs of our father, we filed an application under section 3H4, page 21, your lordship find, for apportionment of the compensation under the National Highways Act. Page 21, your lordship find the application.
page 21
Yes, my lord, your lordship find
apportionment yes
for apportionment. Because under the National Highways, 2 phases are there. 1, if the competent authority under 3H3, competent authority can adjudicate, or it should be referred to the civil judge in the civil court for the adjudication of the estate. Now, my lord, can it takes up their position? filed by my learned friends. That is 7 and 8. Well, got
7 and 8, yes.
if your lordship can turn to page 6. Paragraph 6, my lord. With regard to the statement made in paragraph 5 of the said application, I strongly deny and dispute the same, except I specifically submit that the notice was issued on 10th January 2019 for payment of award to late Bhaktivada Chatterjee, father of the petitioners, and response number 7 and 8 for submitting documents by 17th January 2019. As the late Bhaktivada Chatterjee was awardee, previously submitted mandate for e-payment with account details number such and such and proof of identity dated such and such. The entire award of Bhaktivada Chatterjee has been deposited in the State Bank of India dated 18th February 2019 for the credit to the said account. Therefore, it appears the award been declared in the year 2017 and that it was why the late Bhaktivada Chatterjee was alive and direct to submit details for repayment and the said amount of deposited on 18th February 2019. I have got it. And the Bhaktivada Chattopadhyay died on 18th June 2018. So two things, my lord, cropped out from their affidavit. Is there in the year after the death of the father, the notice was issued, which was received by the respondent number 7 and 8. And it has not been informed to the authority for the purpose of, it is not brought to the authority that he has father died. So now the two steps are there, my lord, you knows very well than us, my lord. Once the award I did the procedure, my lord, then it will be non-verified award. Subsequently, my lord, the heirs will come and that award record to be verified. Yet they have, what they have done, they have simply child without disclosing the father died. Now, my lord, second step they have taken is that the father executed purported will in respect of the entire property, which is the in favor of 7 and 8, and that will is subject matter of probate, which become contentious. That is your lordship in paragraph 8 of the opposition.
Yes.
Now, my lord, this will was made on 21st November 2018. My lord will find and the death of the father. That your lordship from the page 21 of my writ application. Paragraph 4. On 4th June 2018. Yes, it may, my lord. I am only drawing lordship attention so for the purpose of the statement made on oath. Paragraph 4, 18/6/2018. Right. So in respect of the will, which is purported to be executed sometimes in 21st November 2018, and the court proceeding in respect of the said will has been initiated by the parliament such and such, and the said proceedings of the requisitor have entered appearance and contested the same. So these are sum and substance of their contention. Now, my lord, can you consider that we have lost a complaint when we came to know that the entire money was paid to the private respondent? We filed an application under 156(3), and the privacy observed that yes, there is some defalcation of the case, and accordingly, my lord, a proceedings was initiated. Man, can you turn to page 29 once?
Page 29 of
Of the opposition, my lord, I'm relying upon their documents. This FIR registered on the basis of the application filed under 156(3).
এটা দিন বুকমার্ক দিন তো এই যে এটা দিন তো এই যে আটা দিয়ে এটা লাগাবে কি বলে এটাকে yes
Page 29, your lordship find
Hmm.
the copy of the FIR.
what is the complaint
Complaint, my lord, is page 30. It is specifically mentioned that by suppressing the fact of the death of the father, the entire award amount was accepted or misutilized by the private respondents.
the share will be 1/4
Half, my lord.
1/4 share or 1/5
2/4, my lord, two petitioners are there, two daughters are there before your lordship.
so each of the
Yes,
legal
1/4, you'll get 1/4 subject to Sanjeev Ganguly, Shivli
in
Mukherjee.
para 6 you say that the accused person is entitled to get 1/5 each
Yes,
How?
another daughter who died predeceased daughter.
Oh.
His daughter is there. She died in the year 2021.
Okay.
Another daughter, Vivarani Ganguly, died on 12/10/2021, my lord.
this you have stated in your writ petition
Yes, my lord, page 21, my lord, paragraph 2.
yes so there were 3 daughters
Three daughters, I beg to be corrected, madam. 3 daughters, 2
three
sons.
daughters
1/5.
one prior to filing of the writ petition she has expired
Yes.
yes
Now, my lord, can you consider what are the privacy findings while filing the charge sheet? Can you turn to page 35? Last but 3 lines from the bottom. The Union of India, my lord, got it. Has acquired a part of the plot number LKS number such and such for construction of national highways and declared award for compensation on 4th January 2019. But before the date of award, Bhaktivata Chatterjee died on 18 June 2018, which I have drawn to your lordship attention. So, the later the accused person received the award
yes
over the instant case been award. The award. Yes. And Ashish Chatterjee, Dev Kumar Chatterjee, both of the another such and such, Vardhaman, as per investment, during investigation, I visited the such and such. I am also skipping over the same, my lord. Last, but on 13th July 2023, my lord, you'll find from the middle portion. I had collected report from the said bank which I perused and found that the account is existing in the said bank in the name of Bhaktipada Chatterjee and Devkumar Chatterjee jointly. Of Anandanagar, such and such, the account has credited an amount of 86 lakhs and odd as reward or award of awardees, whom the land has been taken by the National Highway Authority. On 21st August 2023, they collected the death certificate of the Bhaktipada Chatterjee, son and such, who was expired on 18/6/2018 and which was registered under Durgapur Municipal Corporation registration such and such on 22nd June 2019. During investigation, no fruitful evidence could be gathered in connection with IPC number 468. Therefore, the sum is charged for 20 such and such. So it is privacy, my lord. It appears that one of the son was the joint account holder. It was not brought to the notice either to the bank or to the authority. Because in their application, they have actually said they have received the notice for payment of supplying of the documents of the father, because the notice was issued in the name of the father. That your lordship may kindly takes up, my lord, the report filed by the state.
When was the amount credited?
Yes, the amount was credited on the account is after 2019. And May. Report. It was credited on, my lord. (18 to 2019). That your lordship will find from the report filed by the state itself.
Which page?
Page one, state report, my lord. This is,
Report, yes.
my lord, got it? State report. Second page, my lord. After scrutiny of available record, it appears the notice has been issued dated on 10th January 2019 for payment of award to Bhaktipada Chatterjee, father of the petitioners and the respondent number 7 and 8, for submitting documents dated such and such, if not submitted earlier. As Bhaktipada Chatterjee's awardee has previously submitted mandate for repayment of account number such and such and proof of identity dated 22nd July, 12th July 2017. The entire amount of Bhaktipada Chatterjee has been deposited to the State Bank of India by memo number dated 18th February 2019 for the credit of the said account. Your lordship may kindly on the next page, your lordship will find
Yes.
the notice was forwarded in the name of Bhaktipada Chatterjee, my lord got it, which was received by respondent number 7 and 8. In their opposition, they have admitted that this notice was received by the respondent number 7 and 8 after the death of their father. In spite of that, what I am submitting to your lordship, they did not brought before the authority that yes, he has died. These are the, it can be termed to a verified awardee, and pursuant to which, my lord, the amount was paid. Not only that, that account was kept alive after the death of the father, and it is continued till the amount was not realized. Because the death was informed sometimes in 2023. That your lordship will find from the report itself, page 36 of the opposition of the respondent 7 and 8. On 21st August 2023, collected the death certificate of Bhaktipada Chatterjee, son of such, who expired on 18/6/2018 and which was registered under Durgapur Municipal Corporation 22/6/2019.
Yes.
So this is the gamut of the case about the. Now, my lord, what relief I can pray before under Article 226? This is the subject matter first. I am entitled, if you logically turn to 3H4 of the step.
বইটা দিন ন্যাশনাল হাইওয়েজ অ্যাক্ট
Can consider 3H3 and 4. This is the amount under section 3H, where several persons claim to be interested in the amount deposited under subsection 1. The competent authority shall determine the person who is in opinion or entitled to receive the amount payable to each of them. Next, if any dispute arises as to apportionment of the amount or any part thereof, or to any person to whom the same or part thereof is payable, the competent authority shall refer the dispute to the decision of the principal civil court of original jurisdiction, within the limits of whose jurisdiction the land is situated.
Now this stage has gone.
So the 3 has gone.
3H4
3H4, my lord. Now, my lord, what happened? 3H4, if the amount is deposited, then also the authority has the right to send the matter before the civil court. If he otherwise says, when he brought to the notice, my lord, what to whom the same shall part thereof is payable, the competent authority shall refer the dispute. My lord, this provision was interpreted by this honorable court in coordinate bench. My lord, I'm Royal Lord, also in division bench. জজ সাহেবকে আগের দিন আমি দিয়েছিলাম জাজমেন্ট দুটো আছে কি জজ সাহেবের কাছে? জজ সাহেবের কাছে আছে কিনা? এইটা কি আছে কিনা? 2084 CHN page 9. 2018 volume 4 CHN 9.
উচিত
When your lordship was there in the system, and the occasion to argue this matter.
আর কোনো ফাইল আছে?
Yeah, I read out and hand over a copy to your lordship, my lord. So my learned friend can also be considered.
Oh, it is here. Which are you reading?
Yeah,
CHN 2018
2018 volume 4 CHN.
para 3.
Yes.
12. Yes.
The dispute according to the appellate petition arose when the special land acquisition officer such and such national had proceeded to award the compensation for the structure to the said plot. It is the case of the appellate petition that the notice of hearing of third were issued by the special land acquisition officer on the appellant, his brother Pradeep Kumar Datta, and also one Sujit Kumar Datta, son of such and such. Pursuant to the hearing memo number such and such, informed the appellant that by registered deed date such and such, Sujit Kumar Datta acquired a plot of land which was vacant, and on inquiry revealed that the Sujit Kumar Datta thereafter made construction on the same vacant plot. The Sujit Kumar entitled to get compensation for the structure value that stood his acquired plot, there being no restraint order against the payment of structure value of the plot number such and such. The said competent authority found no justification to withhold the payment to be made to Sujit Kumar Datta at the instance of the appellate petition. The memo there was under challenge in this writ application. Now, my lord, this was the sum and substance, my lord. Now the payment was made. That your lordship will find. Paragraph 11, my lord, turn to paragraph 11. But following from your lordship, the honorable division is also on the consideration. Once the payment has been made, then how can they exercise or under Article 2 says? Setting aside the said memo dated such and such, whereby my lord, the Sujit was declared to be the sale owner and intended to get compensation for the structure. By allowing the writ petition at this stage will be meaningless, as compensation for the structure has already been awarded to Sujit Kumar Datta in the meantime. So we are inclined to set aside the same for the reason as discussed above. We therefore direct the competent authority land acquisition under NH Act 1956 and Additional District Magistrate Nadia consider the matter for awarding compensation with regard to the structure situated such and such afresh, and to pass a reason order after affording a reasonable opportunity of hearing to Dilip Kumar Datta, Pradeep Kumar Datta, Sujit Kumar Datta, and upon considering the materials they may place before the exercising power vested in him under provision 3I of the National Highways Act 1956. This exercise should be completed expediently but not later than 6 months from the date of completion of the protested copies of the order. If the dispute cannot be resolved by the said competent authority, he shall immediately refer the matter to the district judge Nadia, invoking the provision of H4 to the said act and such and such. In the event the competent authority land acquisition under 1956 find that the Sujit Kumar Datta is not entitled to any compensation for the structure, or the dispute cannot be resolved at his end, the said Sujit Kumar Datta shall deposit 4,80,486 the competent authority under National Highways Act within a period of 2 weeks from the date of the said order to the competent authority. The competent authority in the land acquisition under National Highways Act this shall invest the said amount. These are the consequential order. So the power which is there, my lord, under the National Highway Act for referring the matter does not completed or does not comes to an end as soon as they have disbursed the amount. If subsequently it appears to the dispute has been cropped up before the National Highway Authority or competent authority, the competent authority possesses the power not to investigate but also take steps for referring the same to the authority concerned. The direction that you have to, according to them, the whatever amount they are entitled, they will keep the rest of the amount will be deposited. Now, my lord, on the same manner, my lord, what it makes of this honorable court? দেখি দেওয়া আছে যশোরকে একটা দেখো 2023 SCC online Calcutta 305 যশোর Calcutta 305
Yes.
It is very good. And I'm drawing lordship attention so far the paragraph 5 onwards. The respective private parties have filed affidavit opposition, affidavit reply in WPN, which are practically the replication of their application. Here, my lord, what happened, my lord? The award money has not been disbursed among the parties. On the ground, a amount has already been disbursed to one of the writ petitioner and the rest of the amount was kept because we raised the objection. Then, my lord, it came up for consideration. They filed a writ application for disbursement of the amount. We filed an application for referring the matter dispute to the competent civil court for adjudication. There, my lord, it was held by the coordinate bench of this honorable court. The respective parties have filed their, which is practically the replication of the writ petition. Having got the learned advocate for the parties and on careful perusal of the entire materials of record, it appears to the court that dispute between two petitioners of the above method petition should have been made private respondent in the respective writ petition filed by the other party. To an issue to whether the Shobarani Sarkar was the daughter of Procedural Sarkar or not, whether the death of Shobarani Sarkar Santosh Malik inherited the share of his property of the Procedural Sarkar by a inheritance. This dispute cannot be resolved by the competent authority when the claim of title over a piece of land or property is under dispute. The civil court is competent authority to determine this issue. Therefore, whether it is disposed of by directing the competent authority to refer the matter of the civil judge such and such, invoking the provision 3H4 of the Act, and the learned district shall dispose of the matter favorably within 6 months or not 12 months from the date of reference, made by virtue of the decision of the division bench in Dilip Kumar Datta, which was I have already brought to your lordship attention. This one is direct to refer the dispute to the learned district judge, judgment for decision. The writ petition of WPN, namely Rabindranath Sarkar, is directed to deposit the compensation amount in respect of 14 decibel of acquired land, because admittedly he is the owner of 14 decibel and the writ petition another is 14 decibel. So the quantum of land which is there, my lord, is the 14 decibel has to be deposited by the interest bearing account. The same direction has been passed. So therefore, my lord, I want to sum up my submission in this way. So therefore, my lord, it is not a dispute. The father was the original owner of the plot, which is the subject matter of acquisition by the National Highway Authority. Father died leaving me a 3 years. One is the after that the 3 daughters, 2 sons. Father died on June 2018. The notice was issued by the National Highway Authority in the name of the deceased person, which was received by the private respondent admitted in their immediate opposition for supplying the particulars of the bank accounts and other things, if not already been supplied. In spite of receiving the same notice, any of the authorities, it was that. Because we have the married daughters and the son, which is the address is given.
The details of the accounts was given after the demise of the, or it was given by the
By the father at the time of
father.
2017, my lord, which is a joint account with one of the private respondents.
Yes.
Now, my lord, 2019 has not been informed. Not only to the authority, but to the bank also, where there is a joint account. The amount was allowed to be credited in the said account by giving an impression to the effect that the father was still alive. The amount was credited, it was received by the one of the, because there is joint account father and one is Devapusha, one of the private respondent. In the year 2023, it was informed that the father died. The amount was disbursed in 2019. I lost the complaint because I am under the impression that the entire money has been given to my landed senior friends.
Who was informed by whom?
We are informed from the authority that after acquisition, the money has been disbursed because 2017 the acquisition process started. 2018, we have no occasion to ask for any compensation because father was alive. In the year 2020, after that 20 onwards was the COVID. 22, we came to know my lord, according to made it letter to the private respondent, stress 19 of the writ application. Page 20, my lord, your lordship will find that we have asked the brothers of the private respondent, you should hand over the compensation amount which is payable to us. That your lordship will find page 19, page 20, second paragraph.
Yeah.
As there is no reply, my lord, page 21, we file an application for apportionment. Because once, my lord, it is brought to the notice of the government or the authority that the diet, then, my lord, it is the incumbent of the person who is informed or any notice that who are the heirs, they should be brought on the record for the purpose of verification of the award. Then we are entitled to get notice to that effect. But no notice was served because it has been already been disbursed. So now, my lord, this private respondent has, I can say, in connivance or in absence of any connivance, blessings of the authority, they have got the amount. They have utilized the amount, they have taken that amount. Now, my lord, there is no other option for me to initiate proceedings under 3H4 requesting the issued said, and the person responsible should be directed to deposit the proportionate share of the amount which they have received. And so far the will is concerned, my lord, I have drawn your lord's attention from their affidavit. The will was dated sometimes on, I don't want to make submission on that effect, 21st November 2018. Page 7, my lord, your lordship can mark this. In respect of the, by way of a will made such and such, and the probate proceedings in respect of the said will is being initiated by the private respondent. Page 7, paragraph 8. At the bottom, last 4 lines from the bottom.
Yes.
The person who died, my lord, sometime in June, executed a will in the month of November 28. Clear as it may, my lord, I am not. Because that is the subject matter of dispute which I can take before the authority, before the competent court of law. And that is pending. So, until probate is granted, what is the effect of the filing of the application for granting of probate? So, these are my submissions. So, it should be referred along with direction for the purpose of depositing the other consideration amount. There's my meeting. May I have your lordship leave? Kindly My junior is here, my man. Grateful to your lordship.
Let us read the pleadings of the writ. My learned friend not place the writ petition. He has relied on my affidavit in opposition. Substantiate his case. What initially, my lord, Mr. Rai's client came before this court by couching an allegation in the writ petition saying that there is an hobnobbing between the authority and between the private respondent. Authority was very much aware about the death of the awardee, as also respondents have done this mischief deliberately. That was the writ petition. Now, kindly let us come and see what was the pleading made in the writ petition. Kindly take up the writ petition. Paragraph 2 says what is the description of the land. Then was originally to one late Bhaktipada Chatterjee, and after his death, the petitioners and her two brothers have become owners in respect of the proportionate share of inheritance. The name of late Bhaktipada Chatterjee was recorded in the concerned record of funds. Thereafter, paragraph 3, your petitioner said that the National Highways Authority initiated a legacy of such and declared award of for compensation on 4th January 2009. Then paragraph 4, Bhaktipada Chatterjee died on 18 June 2018, leaving behind his surviving his two daughters, the children of predeceased daughter, namely such and such, and the private respondents herein as his heirs and legal representatives, and as such they became the joint owners of the estate left by the Bhaktipada Chatterjee. Since this is by way of inheritance, then your petitioner said that after the demise of said Bhaktipada Chatterjee, the competent authority under NH Act declared award on 4th January 2019, 86 lakhs odd amounts, 40,000. Thereafter, paragraph 6, illegally, your petitioner said that petitioners came to learn that private respondents herein illegally received the aforesaid compensation amount in bad motive from the competent authority in connivance with some other person, although as per law, the private respondents are not entitled to entire share of the said amount, but they are entitled at 1/5 share. So specific averment is made in connivance with the authorities, government authorities. This amount was taken. Then paragraph 7. Your petitioner said that considering the aforesaid facts, your petitioners, through their learned advocate by letter dated such and such, 21st October 2022, seeking directed the private respondents to refund the share of compensation amount of rupees such and such each, along with 12% interest per annum within a period of 7 days. Then your petitioner said that considering the aforesaid facts, your petitioners filed an application on 16th November 2022 before the respondent authority, inter alia prayed for payment of their proportionate share of compensation amount. Then para 9, your petitioner states that your petitioner number 1 by letter dated 22nd December 2022 made a representation before the special land acquisition officer, inter alia prayed for disbursement of compensation amount in respect of their proportionate share. Now, they have relied thereafter 3H4. So their moot cases, there was a nexus between the authority and the private respondents, and private respondents got the money by suppressing the fact. Now, let kindly come to the affidavit portion. When let us see the prayer and affidavit portion. 22nd of February 2023, it was affirmed. Now, my lord, kindly come to prayer portion, which is at page 11. Read in the nature of mandamus, commanding the respondent authorities either to disburse the proportionate share of compensation amount to the petitioners for acquiring the lands of the petitioners lying and situated at district Paschim Bardhaman, such and such, along with statutory interest accrued thereon from the date of acquiring the land of the petitioners till the disbursement of the compensation amount, or to refer the dispute to the decision of the principal civil court in view of provision as laid down in CH4. Then a writ in the nature of mandamus commanding the respondent authorities to consider and dispose of the representation dated such and such. Then transmit the records and rule license. So basically there are two prayers. One is as per section 3H4, you apportion the amount. To consider their representation on 22nd of December 2020. Now, I kindly come to my affidavit in opposition, which they have not dealt with. They chose not to deal with my affidavit in opposition. The Rai has placed only paragraph 6 and 8 of my opposition, did not place the other paragraph.
Yes.
Now, kindly come to para 3 first. Very basics. Writ code is an equity code where if somebody comes up without disclosing material facts before the writ court just to get an order, that tantamounts to suppression and writ should be dismissed on that score only. Now, on para 3 of
Yes.
my opposition says that at the very outset, the answering respondent is drawing the attention of this honorable court that the petitioners have suppressed material facts in the petition in order to get relief as prayed for, and not only that the petitioners made incorrect statements in the said petition, and for such reason the petition should be dismissed in limine with exemplary cost. It's already.
We start on the next day. Not today.
Because
All the items which have been passed over, that will be not. Passed over, not today. 7 টা কি ছিল? 7 কোন সাবমিশন করেছিল ওটা পাস ওভার আছে, ওটা অর্ডার টেক করে দিন, ওটা নেক্সট ডে আফটার টুমরো করতে।
I don't know
Day after tomorrow করুন। Wait, এটা না। Heard Mr. Parthu Protim Roy, learned advocate appearing for the petitioner who concludes his argument. Mr. Supratim Dhar, learned senior advocate appearing for respond number 7 and 8. Also places his points of argument. Next, due to paucity of time, the hearing could not be concluded. 17th. হয়ে যাবে? ঠিক আছে? 17th, top. 17th কি Wednesday? মঙ্গলবার, ঠিক আছে, ফার্স্ট হবে।
Item of seven.
Day after tomorrow. ঠিক আছে। এই এটাকে not this week করব। What is?
Not this week, and মানে during such the body of the year.
Okay, not this week করব। Okay, thank you.
They need to draw and complete the order.
Yes. Document.
Kind to mention a matter. This was taken up on the 27th of November, and my lord was pleased to fix it today, my lord, at 2 p.m. Now,
আচ্ছা। এটার সাথে আরো অ্যাপ্লিকেশন আছে ওগুলো
may I
কবে
only
আসছে
humbly submit one thing, my lord. This is an application for removal of the receiver. Now, the receiver is based in Shiliguri. That is why my lord had directed that please inform
Yes,
the
yes.
other side. I had informed. Now, this application is pending for 2 years now. Even on the last occasion, an adjournment was sought for, my lord. I had objected. I would only humbly request kindly fix any consecutive 2 or 3 dates whenever my lord's diary permits. My lord, kindly fix it. We want to finish this, my lord. A property in Shiliguri has been taken possession of in a suit filed before this High Court, my lord.
দেখুন চলে গেছে কোথায় মান্থলি লিস্ট which are the other applications which the other side has filed?
Well, that for addition of party. Well, that is a GA8 for addition of party by some third parties. My lord. My application has got nothing to do with. My application is for removal of the receiver.
এই সাইডে তো হবে না
My lord, I don't mind if it is on that side of the vacation, but my lord, consecutive to 3 days. Otherwise, we'll never get this application heard. 1 year they took just to file their affidavit in opposition. And it is there in their
একটা
interest
date
that the
fix করুন।
application is not heard.
হ্যাঁ মান্থলি লিস্টে নিয়ে যাবো না হ্যাঁ 7th একটা ডেট ফিক্স করুন 7 জানুয়ারি
7th January. Will it be my lord's pleasure to record an order? I'll inform the receiver again because otherwise they would say that I wasn't aware.
আবার সাপ্লিমেন্টারি করতে হবে আজকে লিস্ট ইট ইজ রানিং ইন দ্য লিস্ট
It's not in the list, my lord.
তাহলে আবার নিন মান্থলি লিস্টে কততে আছে ওটা জান সাপ্লি করে দিন Mr. Devdut Mukherjee, learned advocate for the petitioner, submits that by order dated 27 November 2024, the matter was listed today for hearing. However, this has been listed in the combined monthly list of January 2025. Your matter has been listed in January 2025.
I'm not aware of that. It was supposed to be returnable today, my lord.
January 2020. He seeks for fixing a date for hearing of the application being GA5 of 2022. The other GAs are not related to this. The other side will come and they say that the other not. Okay. You give notice to the other side as well as the receiver.
Absolutely, my lord. I'll do that.
Place this matter on 7th January. 7th or 7th January 2025. Learned advocate for the petitioner directed to serve a notice upon the learned receiver, Mr. Milan Kumar Sarkar, as well as Mr. Ratul Das, learned advocate for plaintiff
My
respondent.
lord, Mr. Deepak Kumar Jain is the advocate on record, my lord.
Mr. For the plaintiff respondent,
Yes, my lord.
Mr. Deepak
Ratul
Kumar
Das is
Jain.
the counsel appearing.
Mr. Deepak Kumar Jain. Ratul Das हो जाएगा, Mr. Deepak Kumar Jain.
My lord, will it be my lord's pleasure to fix a time, my lord? I would humbly
First you get the date, then we'll see in time. On 7th January, take it up.
Very good. I'm grateful. Therefore, proceed.
Your Lordship, item number 9 of today's list, Your Lordship. I'm praying for a note today in that matter.
Wait, let the list be called. Wait. Document.
Original cell daily list item number 1.
Before we dismiss, none appears on behalf of the plaintiff. Accordingly, let the suit being CS 394 of 1971 and the connected applications be dismissed for default.
Item number 2.
Your Lordship has been pleased to include the matter today at our instance, but we have been constrained to mention this matter because of an extremely urgent situation which has arisen. Your Lordship would recollect that in this suit, Your Lordship has passed an order for sale. There are joint receivers there in the property, valuation done, sale order passed. Now we have come to learn that somebody, after getting getting knowledge of this order, are taking steps to demolish. The boundary wall has been demolished in part, and a portion of the property they have already started excavating. But if I may hand up photographs to your lordships.
You have to make payment of remaining balance of remaining 8 days. What steps has been taken before the local court? I mean, the court having the jurisdiction.
No, this is recently complaint has been lodged, but we are advising them to take out some 144 or some proceeding, something of that sort. But my lord, the property is custodial legis. My lord, the receivers are there in the property. So my lord,
Compliance report.
In compliance report means
well, the compliance would be so far as publication is concerned, and immediately thereafter, my lord, this is what is being done.
Compliance report.
maintain the boundary wall. In December, the letter receivers intimate the SHO Rajwal and SP and by an email about such incident by attaching a few photographs.
Compliance report.
Yesterday, I told that you take out an application with certain prayers. Some prayers, you take out an application. Since that is not on record, how can an order be passed? What do you seek?
If it so commences to your lordship, a police picket. But as of now, a police picket,
Huh.
my lord, and we'll come back with an application. Because
File
we
an
feel that
application?
by the time we file an application and serve and come back to your lordship, things would be demolished. So, my lord, immediately upon coming to learn yesterday, my lord, my learned junior had mentioned, and your lordship's pleasure was to include it.
As soon as the application is filed, you mentioned.
We have lodged the police complaint.
As soon as you come up with some prayers. Huh?
Yesterday, we have lodged a FIR on 9th of December.
Okay.
And my lord, we have lodged now. FIR has been registered.
Okay. Asuntu, this matter is appearing under the heading to be mentioned.
My lord, in our
Learned-
compliance report in paragraph.
Learned joint receiver. Special officer or receiver? What is your rank?
Receiver,
Joint receiver files compliance report, which is taken on record. Mr. Choyan Gupta, learned advocate for the petitioner, submits that after publication for sale, the entire boundary wall of the Rajgarh property has been demolished.
No, for the entire property. But the boundary wall has been demolished and excavation has been started inside.
কি বললাম বিল্ডিং ভেঙে দিয়েছে entire boundary wall has been demolished. Boundary wall has been demolished.
Portion of the boundary wall, they have
Portion of boundary wall has been demolished. Portion boundary wall has been demolished. he seeks to take out appropriate application. FIR has been lodged, no? He also informs the court that against such incident, FIR has already been lodged. He files a copy of such FIR, which is being number 0720 dated 9th December 2024, which is taken on record. He seeks to take out appropriate application. The joint receiver is directed to circulate the compliance report amongst, you are the plaintiff, amongst the plaintiff and defendant numbers, as well as the answering defendant, appearing defendants.
Come to page 28 of our compliance report, there is the advertisement. In that said advertisement, we have, as per the order of the court, that date of proposed sale is fixed on December 23rd, and today is the last date for bid, and we are started accepting bid, my lord.
Okay, you accept the bid? No.
The matter may be put up on 23rd of the December, my lord. For
কবে আসা ছিল অঞ্জন বাবু? Out of list. Matter to go out of list with liberty to mention. Yes.
Should be giving directing the matter to go out of list. No, this matter. Some protection.
When did you file the application?
But in the meantime, what I was humbly.
No. You file the application. File the application.
My lord, we have already mentioned in our.
But we shall come with an application.
The protection has been given to you by way of an injunction. The entire property is protected.
To record that the properties needs to be protected. Kindly sees the 2nd August 2024 order. If my lord kindly turns to the page 3, may I hand up a copy? May I hand up
Second.
2024.
Second August in which GA?
Kindly turns to my lord page 3. Top 2 lines, for which reason the properties of Mrs. Girdhari and Gandhira. So your lordships had been sort of protecting the properties and pass necessary directions. Now the properties are already custodial. They receive joint receivers are there. But what I was humbly beseeching, at the initial cost of the plaintiff, if your lordship directs the joint receivers to get the police help and the police picket there. Because otherwise, well, by the time we come up to your lordship with the application, we apprehend the entire building would be gone.
In our compliance report in page 15 and 16.
The local police station, the direction has already been given.
Yeah, but for the purpose of inventory. But I was humbly beseeching if there could be police picket.
Will it help you?
But kindly grant us some protection. I shall come back with a formal application. I'm not shying away from
paying any hate to us, my lord.
There are local goons are there. It's impossible for the joint receivers to ward them off.
And my lord.
And your lordship was pleased to give police protection for the purpose of inventory. That has been done. But kindly consider a police picket. On my cost and upon my compliance of the necessary formalities for the same. Because I need to write to the local
On the date of inspection, my lord, we have visited the local police station. They did not provide us any assistance for inspection of the property. After 3rd December, this has been started. And the police authority says that SGM is the local authority. So there is no order up to on the SGM. But we say that the local police officer, yes, we have served a copy of the order to the local Tehsildar. The police officer said no. To please serve to the local SGM, and local SGM refused to receive any order from your lordship's court because the name is not mentioned there.
SDM.
SGM.
Local authorities was not mentioned in the order. Local authorities was not mentioned.
then served to these authorities.
So what steps have you taken for filing any application before the SDM? Have you informed?
My lord, that copy of the order has been served upon these authorities.
Ajha.
Second August order.
Let the joint receivers approach the SDM, local subdivisional magistrate?
Yes.
Hmm.
And my lord, and also my lord,
We
for
have made
police.
certain prayers in our, we have made certain prayers in our affidavit in compliance in paragraph 15.
Now you will also come up with a prayer. That is what I am asking you to file an application.
Come up with an application. Well, as early as possible, I shall come up. But till
You-
such time, kindly grant some interim protection, my lord.
Yes, I am passing an order directing him to communicate this order to the SDM for taking necessary steps.
And for police picket at my cost. Because
So
police picket
SDM will
is for
pass.
cost.
So go and file an application before the SDM seeking for police help.
I shall file an application. Kindly give that liberty, my lord, I shall file.
Okay. Asum. হ্যাঁ কি বলেছিলাম বলুন তো the learned joint receivers are also granted liberty to make necessary applications before the subdivisional magistrate. What is this place? What is the place? Rajgarh, subdivisional magistrate Rajgarh, who shall take necessary steps, including extending police help for protection of the properties from encroachment by any third party. You approach the subdivisional magistrate, and so far as extending of police help is concerned, the magistrate has been directed to take steps. Any.
Other sale process is will be continuing. Sale process will be continuing.
Sale process will continue.
Some sort of interim protection before we could.
Let him approach the SDM. The SDM shall take steps for extending police help for protecting the property from encroachers.
Exactly what had fallen from your lordship. If that could be reflected in the order, that would do a protect the property from the encroachers. To ensure that the if that could be kindly
Or read out the order. Last up, order.
Joint receiver are also granted liberty.
Now the matter to go out of list with liberty to mention.
So
report. Photographs to দিয়ে দিন. Photographs টা Yes.
Item number 3.
Partial direction of I have served a copy upon the CBI.
CBI. Who is representing the CBI?
Service.
You have received the copy.
They have received.
CBI has given you this.
By hand delivery. I have sent them and by hand delivery. We have not received any copy, my lord. till date. Page 14, my lord, my cover letter. The seal of the their office.
This is affidavit of service on 29th November. And,
Serve along with a copy of the application and order.
অঞ্জন বাবু, আমাদের সিপিআই কি কোনো প্যানেল আছে আমাদের অরিজিন সাইডে? হ্যাঁ, হাইকোর্টে আছে। কে আছে বলুন তো সিবিআই, জানা আছে? এটুল জি, আচ্ছা। আর ইউ আছে না, ওই ত্রিপাঠী না তিওয়ারি, অনেকেই আছে। হুম, তাই করুন। This matter is appearing under the heading to be mentioned. Is there any panel of advocates under the CBI?
Something, my lord. First and foremost, my lord has directed CBI to comply this 5th March order.
Yes.
And 5th March, my lord, third last paragraph says CBI is directed to provide a certified copy of the document. Perhaps how CBI is going to provide a certified copy, because they have seized the. This is for CBI to come and
They have
say.
not till date they have not approached my
My
lord.
lord, what can be done is, because I am also getting affected because of this
Counterclaim.
So, my lord, let the DSG, I think the learned DSG has been representing the CBI all along in all the court. Let my learned friend serve the learned DSG who has been appearing for CBI, because CBI has been representing everywhere.
He is your ASG.
ASG, my lord, the pass a direction to serve it upon the
I
office
am
of
ready.
the
I am
ASG.
ready to support.
From there it can.
Affidavit of service filed on behalf this to be mentioned. Yes, sir. This matter is appearing under the heading to be mentioned. Affidavit of service filed by the applicant is taken on record. Mr. So and so, learned advocate appearing for the plaintiff, submits that pursuant to order dated 22nd November 2024, the plaintiff has served copy of the order of this court upon the Superintendent of Police CBI.
I know you copy of the petition, my lord.
Along with copy of the orders of this court, along with copy of the application being GA 37 of 2022 upon Superintendent of Police CBI ACB Kolkata on 29th November 2024. However, the certified copy of the documents have not been handed over till date to the plaintiff in terms of order dated 5th March 2024. Learned advocate for the petitioner is directed to serve copy of the order dated 5th March 2024 and 22nd November 2024 to the office of Learned Additional Solicitor General for information and necessary compliance. List this matter in the monthly list query.
May I suggest, madam, may it be on a fixed date because my lord is seeking their appearance. So may it be on
Did it
fixed-
appear on bulletin under the heading to be mentioned on 6th?
fixed. Great.
Item number 4.
Purikir. Not to the
Item number 5.
My lord, I'm for the plaintiff, my lord. DW cross, my lord, started. Today, my lord, Pradeep Datta has not come for some personal difficulties. My lord, kindly keep it Thursday, my lord.
It's evidence of the
DW,
DW.
DW cross examination of DW2 is going on.
Accommodation. How many days you will require?
first time, today, first time. I'm for the
First-
plaintiff.
The procedure.
Only one day?
You will cross-examine the witness.
Yes.
That will remain present reasonable date. Defendant. Where is your witness?
He has not given.
I have informed that I.
He informed that senior is
My lord,
available and senior.
Why?
my lord,
Since you will not be cross-examining the witness.
my lord, Mr. Pradeep Datta,
He's out of station, I think.
Stands to learned advocate for the defendant seeks accommodation. Coordinator date. List this matter on
my lord, keep it Thursday, my lord.
no আর কোনো এই সাইডে নয় জানুয়ারি আচ্ছা একটা লাইন আটকে হ্যাঁ The witness Mr. Deepak Kumar Daga is also not present. 14 January. List this matter on 14 January 2025 under the heading witness action.
Item number 6.
G applicant.
My friend, subject to lordship leave. I'm really grateful, my lord, on the last occasion, his lordship accommodated me on my ground. I deeply to express my gratitude, my lord.
Yes.
Last occasion, I have addressed your lordship, my lord. This application is necessitated, my lord, to hand it over the puja pala to one group of Sevait to another group of Sevait, my lord. For the lordship better understanding, my lord, last occasion I have sought certain order passed by this honorable court, my lord, regarding, my lord, the handed over of pala and, my lord, to appointment of Sevait, my lord. So my lord, I feel, my lord, my landed friend has no objection, landed senior friend has no objection regarding, my lord, the handed over.
That is the system followed.
That is the system followed.
Lordship kindly goes to page 10.
Upon the present applicant Seva,
And 8. My lord, I don't object. let him be appointed as the joint receiver. But so far as prayer B, or this is a little disputed.
So prayer is what to hand over the pala to Sebai. No, no, sir. Prayer is alada. Prayer B, prayer ঠিক আছে. Prayer A, prayer is something.
But prayer A, I have no objection.
Yes.
You are pressing for prayer A only.
Prayer A only. No, we are praying for all the prayers. Now, my lord, if they want to file any objection, my lord, I have no problem.
Prayer B is for disbursement of funds to both the parties. I mean, both the families of Shibai. Malad, already last year we have handled it. We have.
You have to. Yes, Mr.
Well, the day he is here appointed, he is entitled to get the.
Once he becomes a Shibai.
No, what is the objection regarding prayer B?
Outstanding amount.
What you do is,
If she is appointed, he is appointed today. He is entitled to get any remuneration from this day. No, not any outstanding.
what is the outstanding amount?
The outstanding amount as of now for the Bose family, Malad, is on and around 25,000. And Malad, already.
What is the outstanding amount for? Her claim. Well, let that be placed. I shall give my opposition.
Give a report in that regard. The receiver.
The receiver will give a report to your lordship.
Give a report. That's
So right now I'm not passing any order for filing any affidavit in opposition. Let the report come. Thereafter you go through the report and you make your service.
The joint report on behalf of the both the receiver. There are two receivers, my lord.
Who is the other one?
It's the other one.
Or advocates on
The
record.
advocates on record are both the side. Both the side.
They have been appointed as receiver.
The due date of handing over pala, my lord, is I believe
This
on
is an
15th.
application for appointment of the present applicant as Sebayat and for disbursement of outstanding amounts to the applicants as well as respondents herein. Mr. So learned advocate appearing for the respondents submits that though he does not oppose to the prayer A of the notice of motion, however, with regard to prayer B, a report is to be filed by the joint receivers to ascertain the outstanding amounts. In view of such submissions, joint receivers are directed to furnish a report disclosing the outstanding amounts lying in their account. It is receiver's account.
The account of the Malad.
Lying in the account of the
Sending of the receiver.
No, there are
no, whether the account has been maintained by the receivers or not, that is what I am asking. It is DT's account. DT's account by the on the returnable date. List this matter on
The account is standing in the name of the Devotar state.
Sri Sri, for the DT Sri Sri Ishwar Kalimata Thakurani. কবে আসছে? List this matter on combined monthly list.
Report is filed,
generated.
my lord, we shall take up exception to that.
If you have got no objection, then we can dispose of the application.
Item number 7.
I beg to appear for the same chapter.
Sorted.
Number 2.
That matter.
Yes, that matter. My lord, there is a report from the registrar origin side.
Have you checked?
Yes, my lord. All the discrepancies have been removed. It's tallying with the report of my lord Justice Raja Basu. It's already there. Now, my lord, I'll be pressing for the application now.
since the report. is
Let me
already
go
there.
through the report
Yes,
first.
kindly. So we didn't get a copy of the report.
My lord.
That may be circulated.
Again, a new name has Brook Bond Estates. You did not indicate on the last date.
There is, it was only misspelled, Milo. That we have already
So
corrected.
now it is resolved. Yes. What is your application now?
My application is for taking custody. The advocate record would have taken custody, and it has to be converted electronically. Those are physical shares and divided amongst the parties as indicated in the report of my lord. There is a ratio. Now suppose, my lord, we have 10 shares now, and there has been splits. It can go up to 40 shares, but the ratio will be maintained. My lord, what I say, my lord, my learned friend appearing as for the defendant number 1, I believe he has some objection. He was just indicating me. He has some objection in me taking the advocate record of the plaintiff taking the custody of. We have come, we have amicably thought of a name who may be appointed as a commissioner, my lord. He may take custody of the properties, my lord, the share certificates, convert it to in the electronic form,
And file report.
divided amongst the parties. The ratio is indicated in by Justice Rajabhat these minutes.
Okay.
We have come up with a name. If my lord doesn't indicate otherwise, my lord, we can suggest a name. At our cost.
Yes. You are for?
For event number 2, man.
2. You are for 1. By the present application, the applicant plaintiff has made the following prayers. A, B, এখান থেকে master summons, notice of motion. Yeah, it is contained in the application that the share scripts and other investment instruments which are presently lying in the custody of the registrar original site stop. The said share scripts and other investment instruments are required to be handed over for handed over by the learned registrar original site from its custody for distribution of the same amongst the parties in terms of the report of learned commissioner of partition. Mr. So and so, learned advocate for the petitioner. আচ্ছা এর টপে না একটা এ দিয়ে দিতে peruse the report of learned registrar original site dated 7 December 2024. হ্যাঁ ওটার পরে একটু কন্টিনিউ করবেন একটা প্যারাগ্রাফ। On the last occasion, certain discrepancies were indicated by the learned advocate for the petitioner plaintiff, and the direction was passed upon the learned register original site to furnish a report after checking the records with the comparative chart furnished by the plaintiff applicant. From the report of the learned registrar original site as well as submissions made on behalf of the parties, it manifests that such discrepancy has been removed. Next paragraph. Learned advocates representing for the plaintiff, defendant number 1 and defendant number 2 propose for appointment of a special officer for distribution of the share scripts and investment instruments.
Yeah, it has to be converted electronically first.
After converting electronically. Considering the amendments made in the application, the report filed by the registrar and the submissions advanced, let
You all need it. We suggest the name of Mr. Sachit Talukdar.
Sachit Talukdar.
Milo Justice Talukdar.
Mr. Sachit Talukdar, learned advocate. He is in which bar?
But that I have to. I'll just check and indicate.
Let Mr. be appointed as a special officer to distribute the share scripts and investment instruments amongst the parties after, what did you say?
Converting them
After converting the same electronically.
He may also be entitled to appoint some person. He will not be do it. He cannot do it alone.
Learned special officer is granted liberty to appoint an expert for conversion of these share scripts and investment instruments electronically.
In the ratio as indicated, I'm very sorry to do
Such distribution shall be made in terms of the ratio as mentioned by the learned commissioner for partition in its report. The
22nd of
learned special officer is entitled to receive remuneration. How many days it will take to?
It will take time.
It will take time. So initially, make it 5,000.
I think it requires more.
Huh?
I should not be unfair. It would require something more. More dikhai.
Something more হচ্ছে expert থাকবে
To manage.
কত করে এগুলো?
It's an arduous tax move.
7,000 করে দিন 7,000. Learned special officer shall furnish a report on the returnable date. How long it will take?
It will take almost a year.
Year.
Let it go out of the list, Milord. We'll mention if it
It will matter to go out of list with liberty to mention.
My lord, a copy of the
copy of the report may be circulated.
The report of the registrar dated 7 December 2024 be circulated amongst the parties.
As well as the learned commissioner.
as well as learned commissioner who is appointed.
Special officer
The shops.
upon the parties as well as special officer. Yes.
Deeply obliged.
Adjourn motion, item number 8.
Well, this is that matter where the same property was sold twice. Why not?
Mr. Chaudhary, I was thinking of the fact that the subsequent sale being carried out by dint of an order of this court, this application, since there is a contention of the parties of the applicant, that there was a suppression of facts and it was a fraud upon the court. As far as your application's prayer is concerned, that is for setting aside of the sale. But the other thing which I like to have your deliberation on is that until and unless the order of that court, subsequent order of the court, is recalled or in a way it is modified, I think the setting aside of the deed of the subsequent one will be a. For that reason, I was thinking of releasing the matter so that it can be placed before Justice Sen, because he is. You see, who passed the Justice Sen passed the order, no?
My lord, he may have passed the order, but he passed the order because by consent of parties.
Anyway, but
it was not that there
we
was
are.
any application of judicial mind.
That is correct. That is correct. But
My lord, what I was submitting is, see, I'm not really interested in anything else. I'm interested.
I
in
have understood.
Whether
I've
that,
understood.
the second deed remains, not remains, I'm also not interested.
But the order is there. That order has to be.
I'm not even a party to the suit. I didn't even know about the order. I mean, how could I go and ask them?
If this court passes an order, first of all, it has to deal with the order passed by this in the subsequent.
My lord can always modify the relief and grant the recall. My lord could always modify the and grant the recall. My lord is now taking the jurisdiction that was then being exercised by Justice Sen. So my lord can always do it. My lord can always do it. It is this court's order. It was not Justice Sen's order. And my lord can always modify the relief. If my lord feels that that order should not stand, my lord will recall it. It is not that they are coming and opposing it. And the receiver has also very fairly submitted on the last occasion that yes, all the schedules are the same at the same property.
Where is that order?
Man will take their affidavit in opposition.
I got it. 111 of your application.
Fine. Yes, ma'am. One.
And where is the averment that this was an act of fraud upon the court? I think paragraph 3 of your application.
Paragraph. I've given the details of fraud in paragraph 2 and
Oh. Oh. একটু বুঝতেই পারিনি।
Release করেছে।
ঠিক করে গেল একটু ঠান্ডা লাগছে
এই অঞ্জন বাবু ওই রিকলিং এ যেটা থাকলো ওটা আমাদের কি নোটিফিকেশন আছে বলতো নট রিকলিং করা যাবে রিকল করে দেবো অর্ডার পারবো ইয়েস You have a copy of the valuation report with you?
There was no valuation report made.
What has assessed?
No, on the last date you submitted that you made a valuation of the same property?
That was, we made it through the registrar.
I have
We got the valuation from the registrar.
No, madam, I have not. What has fixed the valuation? I have not.
No, return. The valuation.
The subsequent valuation. Huh?
The valuation is annexed to the deed. I will see their deed at page 80. And my lord will come to page 134.
অঞ্জন ওই নোটিফিকেশনটা বার করুন তো No, this is not by any valuer. This is a valuation of a registration office. No?
Not by the value, but by the. But there are two values there you will see. One is the market value, so-called market value,
Yes.
and one is the set forth value. Because the value, because the court sold it at that rate, therefore they've accepted that value. But of course, I had bought it 19 years earlier for double.
Then how could the registrar's office can give a valuation so less?
My lord, people get managed at times. And because you will see the applicant is a registrar.
আমাকে একটু এটা দেখিয়ে দিন নোটিফিকেশন Mr. Mondal, the properties are same.
I have not gone into.
You have executed a sale deed, no?
The schedules are the same as per the deed. Whether property is the
I
same or
have
not.
not done anything, madam. But the court has directed me to register the same as in Hari's basis, madam. Deed prepared by the advocate for the purchaser, I sign it. After approving the said from the trustees, madam. All are done by the trustees and one of the purchaser, madam. I have complied only for the high court direction, madam.
But then why did you obtain the valuation? The valuation is always obtained by the purchaser.
My name, madam. They have used my name. I have not applied for. I am nothing, madam.
Your signature is appearing in the.
It is in registry office, madam. In registry office.
If you have executed a deal in favor of somebody.
By the registrar office, and madam, I sign it in the registry office, madam. I have not applied for, madam.
In register office, all everyone is signing here, my lord. Because my lord, in
Did you file any compliance report before the court after execution of the deed?
there is
No.
no direction, my lord. There is no direction, my lord. And application was disposed of on the very same day, my lord.
Patient.
I was not appear in court, my lord.
ক্রিয়েটটা কি আছে? আচ্ছা, হ্যাঁ একবার জেনে বিফোর আই একটু পাস ওভার রাখছি। Mr. Chaudhary, it is passed over for some time. Just to check whether there is any notification.
Could it be tomorrow? My father's in hospital.
Oh,
I have to leave.
yes, yes, yes. Day after tomorrow. Day after
Yeah,
tomorrow.
could be tomorrow. Day after tomorrow. Tomorrow. No, my lord,
Then on Friday.
Just you mentioned it, nothing else. That's the only thing, my lord. Will.
Friday তে তাহলে রেখে দাও। Friday তে কত হচ্ছে? 13th না? On Friday.
Then Friday I may have to go down.
Then on Monday? Monday.
Tomorrow I'm here. I could have come. The question of finding out from the registrar, but that will take.
Not tomorrow, on Monday. Monday তে দেখো তো কিসে আছে, কত নম্বর এটা আসবে, মানডে তে এটা করবো। জাস্ট একটু চেক আপ করে নাও। That is the only technical ground because I have understood what you have submitted. Now, if the subsequent does not lie, then what you have played, that is there. But whether this court has that, because I was thinking of it, because it's not just a sale has been done out of court.
I don't always modify the relief. The facts have been stated. I've said it is fraudulent. I've annexed the order.
ও তো থাকবে না, না থাকবে না। টুইসডেতে কত তারিখ হচ্ছে? টুইসডেতে দেখো, আমি ঠিক শুনে নিয়েছি এটা। টুইসডে, মিস্টার চৌধুরী, টুইসডে, টিউসডেতে রেখে এটা অর্ডার করছি না, টিউসডেতে তুমি রেখে দাও। আচ্ছা, এসো। On the prayer of the learned advocates, fix the matter for further hearing on Tuesday. That is, কত তারিখ হচ্ছে? 17, 17th.
Item number 9.
Where is the other side? কি বলছে? তাহলে আজকে ডেট দেবো না, মিস্টার চৌধুরীকে টাকা আজকে অর্ডার রেকর্ড করে দেবো। ওটা ডেট এই কেটে দাও অর্ডার। Sorry, I have ascertained, I'm releasing the matter. On this ground, now there is a order, it should, because this is act of fraud upon the court, which I find. Huh? কন্টেনশনটা রেকর্ড করে দিই।
You can express my lord's view and then say that because that my lord has heard us on.
দিন ওই অ্যাপ্লিকেশন ফাইলটা দিন। This is an master summon. By the present application, the petitioner has sought for following orders. It is the precise contention of the petitioner that in the year, which is the year of your purchase, 2000, the applicant purchased the property just give the page numbers. Purchase property measuring more or less 6 kathas being part of premises number 72 Bon Behari Bose Road in the town of Howrah, by a deed of conveyance by a deed of conveyance executed by way of a public auction undertaken by the order of the court. The sale deed was executed in favor of the applicants by the receiver appointed by this court. Subsequent thereto, in the year, where is the deed of, in the year 2019, on the basis of an application moved by the trustees moved the application. A deed of conveyance was executed by কি বললাম বলুন লাইনটা executed in favor of one Sanjay Mehta in respect of the same property. The said deed was executed in terms of order of this court passed on this 11 this. Dated 7th May 2018. It is categorical contention of the petitioner that the subsequent deed is an act of fraud. The previous deed executed in favor of the applicants have been suppressed before the court by the trustees and the subsequent purchasers. In the aforesaid backdrop, the present application has been filed seeking for cancellation of the deed executed in favor of the subsequent purchasers. It is found from the orders annexed to the application that the subsequent direction for execution of sale in favor of the subsequent purchaser Sanjay Mehta has been passed by Honorable Justice Soman Sen. Since a contention of fraudulent act by the subsequent purchasers as well as the applicants before the court and subtraction of the previous sale deed has been made, this court is of the opinion that the matter be placed before the Honorable Chief Justice for necessary direction. Let the matter go out of list. এখন আউট অফ লিস্ট থাক, অ্যাসাইনমেন্ট যদি হয়ে আসে তো
Item number 9.
not because not today. তখন I
Monthly list of December, item number 26.
I appear on behalf of the joint receivers, my lord. My lord, your lordship, before my learned friend makes submissions, my lord. My lord, may I draw your lordship kind attention? 20, my lord, from 26 to 58. My lord, these matters are all appearing in the monthly list. What I am praying, my lord, your lordship kindly fixed 2 or 3 matters in a day, my lord, so that matter can be heard. My lord, it is not possible for my lord to my lord, assist your lordship. All the my lord matters 26 to 58. Your lordship take up, my lord, in 2 or 3 matters.
But it is also to be ascertained whether the other matters are related with the matters. Suppose I take first 26, 27 and 28. But it is found that the 58th matter is related to 26, 27. Who will assist the court? It's not you can take up piecemeal, because rights of the party in an application is also governed by, has an implication on the parties who has filed application in suppose 58. You tell me if they can be segregated, the others' rights will not be hampered or any sort of that conflict will not arise, then I can take it up.
My lord, so kindly, my lord, give me 1 day time. I shall ascertain actually.
But so far as my matter is concerned, Lord, I am praying for modification of an order wherein I am trying to point out before this honorable court that there was a suppression of fact wherein, Lord, a vested property has been, by virtue of an order of the court, was mutated by the BLLRO, affecting my right, the applicant. So, Lord, my case, in all probability, stands on a different footing of, Lord, modification of an order.
Lord, if I can use the victim for my defense client, so
Several victims are there.
Filed application. But I appeal for this state. Well, it was adequately particular to the super on state's application. But which is state rule that for the trades. So here the state road has also got trades for without discharge of the joint receivers. Without kindly not by
And the
26 in 26.
The receivers are the person, Lord, who have, Lord, with their closed eyes, Lord, sold away the property.
So you have sought for removal of the receiver?
The state has. I was asking for, my lord, the variation of the order, the modification.
Well, in that case, my lord, I think, my lord, your lordship, the application for modification of the order, my lord, so far, my lord, my knowledge goes, my lord, that should be heard by the honorable judge, pass the order. Modification, clarification.
No, that was not. It was before this.
I have no,
এটা 26
ঘরে ফাইল হয়েছিল, তারপরে এটা এখন যেহেতু অর্ডার ক্ল্যারিফাইং এন্ড রিকলিং আছে, after order granted, the determination.
Yes. Yes, Mr.
But your lordship will kindly take up order, Lord, dated 5th of February 2019, Lord, because from there your lordship will know. I'll try to cut short the matter.
Well, in that case, your lordship kindly take up, my lord, tomorrow, my lord. But I shall assist your lordship, my lord.
But I have a written notes of submission for your lordship with reference to the pages. I'll be very short, my lord, in my submission. Just to point out that where, my lord, the mischief has been done.
My lord, difficulty is, my lord, my learned friend state is, my lord, submitting. My lord, this is a suit of 1935. My lord, at that point of time, the Bengal Tenancy Act 1885 was, my lord, invoked. My lord, at that point of there is no ceiling limit. In 1953, State Acquisition Act came into operation. My lord, thereafter, my lord, ceiling limit was, my
No,
lord.
you're ready with the hearing. Let him then place his case.
I am, my lord, saying that law, my lord, in particular this case, not what is the problem? Because several applications are coming. My lord, the State Acquisition Act came into force. My lord, property, my lord, the entire property was, my lord, subject matter of the partition suit. My lord, no return was submitted. My lord, if the no return is submitted, my lord, state is, my lord, duty bound to, my lord, determine the, my lord, ceiling area according to subsection 5 of section 6 of the State Acquisition Act. That was not done by the, my lord, state. My lord, I am, my lord, according to the section 6, subsection 1 of section 6, my lord, the right of the intermediary, my lord, retention of land is automatic. My lord, in view of the judgment of the Honorable Supreme Court and also subsection 6 of section 1. My lord, state, my lord, I do not know which land has been, my lord, retained by the government. But they are every time they are coming into, my lord, before your lordship, they are submitting that all the land are vested land and every application are coming.
I'll show from the records. I'll show from the records.
Unless the land is retained by the government, my lord, government, and which land is retained land and which land is vested land, unless it is ascertained. But it is very difficult for your lordship to consider whether land, my learned friend is, my lord, claiming to be owner of the land, whether that land is my land or that land is government land. This is the difficulty, my lord. That's why, my lord, several applications are coming.
But will kindly, my lord, for my lord's convenience, my lord, there is a short written note.
I shall argue on this.
না, আমারটা একটু আলাদা, আমারটা আমারটা এটা
Item number 36 and 38 are presenting the receipt. 38, I don't have to press for what is going on now. 36 is simplicity application for restoration.
Restoration of
36 of your lordship is today is an application for restoration of GA 206. If that may be allowed, thereafter GA 206 and that we can come and address the lordship. If the restoration can be allowed, that's all. Then I don't need to stick my neck out into this every day.
30 টা পরে নেবো তাহলে। ঠিক আছে।
আমার কনফিউশন হয়ে যাবে প্রচুর।
My lord, your lordship, kindly take up the 26 matter tomorrow, my lord. I shall argue this matter, my lord.
But let me complete my submission. Let my learned friend come tomorrow and argue. Lord, I'll be very short. I'll take only 5 minutes. I'll just take 5 minutes. Lord, by this application, Lord, the ambit of the application, I tell your lordship, was that, my lord, in respect of a property, my lord, an application was taken out by the purchaser. The purchaser, my lord, purchased the property through a court order through the receivers. When the purchasers, Chondi Real Estate, my lord, applied for a mutation, it was denied. The reason of denial was that they were asking for mutation of a property which stood vested in the record of rights of, my lord, the BLLR. They came up before this honorable court by UEFA GA in connection with the suit, which is impermissible. Because, my lord, for a correction of the record of rights, section 50 of the West Bengal Land Reforms Act, my lord, applies, and the appeal under section 54, my lord, it happens. Be that as it may, this honorable court, my lord, considering the application to be a very naive application, directed the BLLRO to cause a mutation in respect of the land purchased by, my lord, Chandi Real Estate, which included, my lord, the vested land. Now, my lord, it so happened that, my lord, my property, which I had purchased, and I have annexed all the documents to show my ownership, that particular property has an access, my lord, through the vested land, because that is the only access to my property. After, my lord, the order was passed by this honorable court, the BLLRO was reluctantly, my lord, was compelled to, my lord, mutate this particular vested property in the name of the purchaser. I came up before this honorable court to seek a clarification that the vested land should not be included in the mutation. So that is the ambit of my application before your lordship. Now, my lord, one by one, I'll just place before your lordship the order of the honorable court at page 131. Lord, these are all marked in my written notes of submission, but be that as it may, my lord, I'll just point out before your lordship at page 131.
এই যে অঞ্জন বাবু এই অঞ্জন বাবু ক্লারিফিকেশন অফ অর্ডার কি নেওয়া যাবে প্রথম থেকে? আচ্ছা, মডিফিকেশন তো করেই হবে। হ্যাঁ, yes.
Page 131, by an order dated 22nd of July, passed in GA number such and such, CS number 970 of 1935. This is a suit pending from 1935. This court had permitted the joint receivers to sell certain properties belonging to the joint estate of Kundu Chaudhary on as is, where is, and whatever there is basis. The said application had been disposed of by passing an order in terms of prayer A to G of the notice of motion. Prayer H of the said application was as follows. Direction and direction be given to the concerned statutory authority for mutation of the said properties in the name of the prospective purchasers. So Mustafa, learned counsel for the applicant, accordingly prays for the appropriate direction on the BL and LRO. Learned advocate for the majority of the shareholders and learned advocate for the joint receivers do not oppose such prayer. All on consent. Since the property in question has been sold to the applicants, it is only fair that the same should be mutated in the names of the applicants. Accordingly, the orders of the BL and LRO refusing mutation, which are impugned in the present application, are set aside. Clearly an appealable order. Somebody comes here, nobody opposes, takes an order from this honorable court, because your lordships believe us, and has, my lord, an order of, my lord, refusal to mutate set aside. Here. Then what happens? There shall be an order in terms of prayer H in GA number such and such, which has been extracted above. The BL and LRO shall effect mutation of the property in question in the names of the applicants within a period of 4 weeks from the date of communication of this order. Since no affidavit in opposition has been called for, the allegation contained in the application are deemed not to be admitted, such and such. Now, my lord, after this, what had happened? Lord, why I am before your lordship? So previously there was a rejection as recorded by this honorable court, and there was a consequential direction upon the BLLRO. Now, my lord, this order was passed, Lord, on 27th of July 2017. And, my lord, in compliance thereof at page 133, the BLLRO, my lord, passed an order.
Yes.
Lord, Lord, kindly turn over to page 135 because that is not a compliance recording order. After getting the order of the Honorable High Court Kolkata original site passed by Honorable Justice Sri Arijit Banerjee Vide GA number such and such from Sri Shulekha Mondol for Chandi Real Estate. I, the undersigned, the PLLR of this office initiated an order sheet on 4/9/2017 in which it is instructed to the applicant to submit the fresh mutation case, and that will be prioritized by me because the old cases being number such and such and such and such, as once rejected cannot be revived in computer. Accordingly, 2 new mutation cases are submitted by the applicant with number such and such and such and such. The said 2 mutation cases are handed over to the revenue officer named Gautam Das for disposal. The said revenue officer, by process of law, issued notices to all the relevant parties on 14/9/2017, fixing date of inquiry on 22nd/9/2017 and the date of hearing on 25/9/2017. After having inquiry on 22nd September 2017, the said revenue officer requested me to take up the case and to remain present during the hearing because he is facing lots of problem in disposing these 2 mutation cases. As the applicant is not in possession and their purchase is not perfect. So he wants to hand over the case to me for clearance whether these 2 mutation cases will be allowed or not. But the doubt has been cast here itself. Being so, on 25/9/2017, I heard that the cases in presence of the said revenue officer and where the applicant and present record holders were also present and they were engaged themselves in excited altercation. In that circumstances, I heard the submission of both parties and asked them all to file their written submission with relevant documents on or before 24/10/2017 after the final date of hearing. After presenting the written submission and documents, the undersigned revealed that before disposing the case, another spot verification is needed to justify the documents and claims of the parties before final hearing. Being so, notices are being issued to all the interested parties today on 29/11/2017, fixing date of spot inquiry on 13/12/17 and final hearing on 18/12/17, where the undersigned will be present and ask the parties to remain present on the spot to justify their claims. Till then, the case is adjourned. Then, the other order sheet is today at 12 p.m. went to the spot along with my said revenue officer, concerned revenue inspector, and one Amin of this office. At first, went to suit RS plot number 1002 corresponding to LR plot number 1060 of Mouja Makurda, jail number such and such, PS Domju. My Amin located the plot with the help of Mouja map. Sri Pradyumna Kumar Ghosh on behalf of Chondi Real Estate, the applicant, and Sri Vikas Pine on behalf of the receiver of Kundu Chaudhuri Estate, the executor of the deed to the present applicant, were present on the spot. On the other hand, Srimati Rita Hajra, that's my client, Srimati Mitul Mal and Somoresh Mondol, son of Ranjit Mondol, the present record holders, that is my client was a recorded holder of the suit LR plot number 1063 were present. The attendance of all are annexed herewith this case record as part of this procedure. On asking the representative of Chondi Real Estate and the receiver of the estate of Kundu Chaudhuri to show their portion of plot and possession, then they could not show the same and only shown me the handmade sketch map location as laid down in the deed, but on scrutiny it reveals that it is already acquired by Land Acquisition Department, PD case number such and such, for PWD roads. And on asking again, both of them confessed that they know nothing about the field. On the other hand, the present record holders, as the names mentioned earlier, clearly shown their purchase portion with boundary wall and hand sketch map as laid down in the deed, which resembles and satisfies their claim. That is my client, and the other person not before your lordship. Afterwards, we went to RS plot number 1023 corresponding to ALR plot number 1082 of same Moja, where Haradhan Das on behalf of the present record holder, Sri Haradhan Hara was present. Similarly, the representative of the applicant, Chondi Real Estate. Chondi Real Estate is a purchaser. This gentleman is not, this firm is really not the real culprit here. and the receiver of the estate of Kundu Chaudhary could not show their possession, we see that a petrol pump is actively running there. Then we come back to the office.
But this petrol pump is on the land acquired.
Look, I'm not concerned with this one. I'm Lord Rita Hajra, that is. The applicant before your lordship is Rita Hajra, in whose name, Lord, the property was already mutated. First time refused, came before this honorable court, the purchaser Chondi Real Estate, took an order, went back, and this is not the second procedure. The order passed is second procedure. And your lordship has already seen, Lord, that Lord, on the field enquiry it was found that the property in which Lord they seek mutation is not PWT road vested, but that is an access to my property.
Oh.
Then Lord, on 18th of December, Lord, an order was passed. Lord, the case is taken up today for final hearing, and both parties, that is applicant and objectors, to part in the hearing through their advocate. At the starting discussion made regarding possession and all, asking the applicant, the advocate on behalf of Chandi Real Estate said that the court-appointed receiver has sold these two plots to them on behalf of Kundu Chaudhary. An honorable High Court ordered to mutate these plots, and they do not know anything more than that. And they do not even want to understand whether the physical possession of the objectors or present record holders are correct, that is as per record or not. They only say that I have purchased, the receiver knows everything. On the other hand, the advocate on behalf of the objectors plays their logical exposition through a booklet which satisfies the reason behind their claim. However, after having extensive hearing, both the parties are asked that after scrutinizing the deeds and documents, final order sheet will be produced on 29/1/2018. Till then, the case is adjourned. Then the next page, 27. The case is taken up today for executing final decision. The deeds and documents as produced by the parties, which are all annexed with this case record as part of the proceeding, are checked and verified and found the following grounds for decision. Grounds for decision for RS plot number 1002 or corresponding to LR plot number 1063. Area is 47 decimal. It appears that RS record that said plot was owned by one Pancharan Bhattacharya, son of Bholanath, contained in RS Khatiyan number as Khutiyan Dokolikar. And actual area was 69 decimal, and from the document it also appears that out of it 22 decimal was acquired by LA department, Vide LA case number such and such, and remaining 47 decimal as owned by said Panchanan, and its ownership gradually changed and transferred by number of registered document and finally owned by the present objectors. That is 14.07 decimal in the name of Rita Hajra, that is my client. 17 decimal in the name of Ranjit Kumar Mondal, 9.96 decimal in the name of Mitul Mal, and 5.97 decimal in the name of Spandan Mal. And all are duly recorded in the computerized LR Khutiyan and are being possessed in the field. That kindly mark this.
Yes.
All the supported documents are enclosed here with this case record as part of this procedure. Similarly, it appears from the RS record that the said plot was owned by one Nolin Krishna Bandopadhyay, son of Jodunath, contained in RS Khutiyan number such and such as Khutiyan Dokolikar, an actual area of 71 decimal. And from the record, it also appears that out of 25 decimal, it reduced by plot Bata plot, and actual area becomes 46 decimal, as it is owned by said Nolin Krishna. Its ownership gradually changed, transferred by number of registered document, finally owned by Haradon Dhara, one of the present objector, and is being possessed by making a petrol pump which is still running. All the supporting documents are enclosed here with this case record as part of this procedure. It appears from the verification of RS and LR, ROR of the land, that the record was with the rent receiving interest before 15/4/1955. When the said interest of the rent receiver was extinguished as per conjoint effort of Section 4 and 5 of West Bengal Estate Acquisition Act, and the actual possessor being the Rayat of the land have been allowed to retain their land as per provision. 6(1) of the West Bengal Estate Act. who are recorded as tenants of the land under the state of West Bengal and who are paying the rent to the state of West Bengal since then as per section 6(2) of the estate acquisition. In such a position, the rayat whose favor the tenancy right were allowed became the rayat who are also allowed right of transfer and inheritance as per section 4 of WPLR Act 1955. And therefore, the rights of the recorded rayat cannot be denied as per the provision of both the West Bengal Estate Acquisition Act and WPLR Act. So far as the statute of WPA Act is concerned, the receiver or the intermediary as the rent receiver ought to have filed the return in B form to retain such land within the specific time limit, and therefore the question of retention of such intermediary does not arise here in this case. Such being the position herein, the rights and interest of the estate being an intermediary has extinguished fully by operation of section 4 and 5 of Estate Acquisition Act 1953. But the Honorable High Court has been pleased to pass an order, vide GA number, upon the undersigned to correct the ROR in favor of the present petitioner who have purchased the land from those receiver and or intermediary, irrespective of all the facts stated above. Therefore, the undersigned is compelled to correct the ROR to comply the solemn order of the Honorable High Court. Well, kindly see the compulsion of this authority. There are three lord characters who come before the court, take an innocuous order, direct correction of the ROR, and the PLR has to do it because there is an order passed by this Honorable Court. In spite of a finding that it stands in the name of my client, my clients are not the recorded owners in respect of the property. And this particular order, my lord, which I have just read out before your lordship, Lord, I am before your lordship seeking, my lord, a clarification. Lord, kindly come to my prayers. At page 30, Lord, I was praying for a clarification of this order, my lord, that it does not, my lord, affect the extent of the property which is owned by me. And, my lord, the mutation should not be affected in respect of the vested land. Because the vested land grants access to my property because it is vested to PWD roads. That is recorded in the finding of the PLR.
Okay. The land which has been vested, it is LR plot number.
That is 1003. Blood, I'll just check and blood. LR plot number 1063. Your lordship will find that 137 blood grounds for decision. I am concerned about that RS plot number 1002, LR plot number 1063. Because here my client is Rita Hajra, who is the owner in respect of 14.07 decimal. And
69 decimals were acquired by the department PWD for PWD roads.
22 decimals subject to correction, blood, because the original the plot area was 69 decimals.
Out of 22, yes, 22.
And the remaining your lordship will find the 47 is owned by this 4 persons arrive.
Okay. Now the entire land has been recorded in the name of Chundi.
Now this order has been passed because the PLLR states
entire 69 decimals.
Entire 69 decimals.
But the land remained unused after the acquisition.
But no, that was being used as a road.
Roads.
Okay. That is the reason I have to come up before your lordship to say that the access road, comprised of this 22 decimal, have now been mutated in the name of the developer, that Chondi Real Estate.
Okay.
And the funniest part is now that the Chondi is saying that it has been mutated in his name and I will not allow access to that property.
Okay. That is all.
That is not that is not my entire notes of submission is not points out to not the relevant pages and not what I have just submitted before you. And if your lordship peruses the order dated 19th February, a gist has been made out there also. 19th February 2019.
Order of
The 5th February 2019. I've got a copy, blood.
yes.
Not the affidavit of service. I was directed to serve, blood.
বুঝেছেন? ওর এখানে ডাউট হচ্ছে। না 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 একবার অ্যাসাইন হলে তো থেকে যায় না কে বলতে পারবে Mr. Mukherjee, this matter was once assigned to Justice Banerjee.
অ্যাসাইন করা ছিল, তারপর রিলিজ হয়েছে, কারণ জাস্টিস রবি কিষণ কাপুরের কাছে গেছিল। আমার কাছে পুরো অর্ডার শিটটা আছে, দেখুন এখানে জাস্টিস রবি কিষণ কাপুরের কাছে লাস্ট গেছে।
This 5th February 2019 order was passed after assignment.
But I do not know, Lord, when the assignment was done, Lord. No, Lord, I'm instructed, Lord, to say that there was a release order even. There was no, nahi?
তাহলে
There's only one order of Justice Banerjee, and thereafter, Lord, I find, Lord, there are, Lord, at least 3 or 4 orders by Justice Kapoor. But I'll do one thing.
My instruction is, my lord, this matter was released by Justice Sinha, Arindam Sinha, when this matter was pointed out before his lordship. But that this is a recalling application, not by Justice Banerjee.
স্কুলে দিয়েছেন যে এটা কোনো না কোনো চিঠি যেতে করেছে
আজকের অ্যাপ্লিকেশন নাম্বারটা কত?
চারখানা অর্ডার হয়েছে
অনলাইন, যেটা আগে ছিল একটি
এটা জানুয়ারি মাস হলে ফেব্রুয়ারি এই অর্ডার রেকর্ড করে কি পাঠিয়ে দেবো নাকি? Is there any order of release?
I don't find, Lord. But Lord, it was heard by Justice Kapoor for at least 4 occasions, I find from the order sheet. I've got a bunch of the order sheet. দেখাবেন? Even Lord, there was a direction for filing written notes, and this is after Lord Justice Banerjee. These are all Lord recently. কোথা থেকে দেখেছি?
নাহলে পোস্ট ফ্যাক্টর অ্যাসাইনমেন্ট করিয়ে নিচ্ছি।
Perhaps this was not brought to the notice of Justice Kapoor.
I'll do one thing, Lord. I'll just regularize. Your Lordship has already heard this matter. Lord, I'll ask my advocate on record to give a letter to Lord the officer of Chief Justice to say that your Lordship has not the determination. The matter was heard by Lord after Justice Banerjee by Justice Kapoor, and it may be assigned to your Lordship.
How can that be? I know.
Also, the division bench was
Ashu, since it is found from the order of assignment of the Honorable Acting Chief Justice dated 8 February 2019 that this matter is assigned to Honorable Justice Orijit Banerjee. In the aforesaid background, the matter is released from my first.
I'm absolutely apologetic, Lord. I did not know about this, Lord. I wasted my Lord's time.
Is there any other applications which assignment has been made in which you are?
Other matter.
এইটা অঞ্জনবাবু বাকিগুলো সব চেক করে নিন যে কোনটা কি অ্যাসাইনমেন্ট হয়ে আছে। আমরাও লিস্ট করে দিয়েছি যেরকম এসছে, এটা ওনাকে দিয়ে দিন।
অ্যাসাইনমেন্টের আমাকে অর্ডারটা একবার বলতে পারবেন কবে হয়েছিল এই অ্যাসাইনমেন্ট ডেটটা? ওটা তো অনলাইনে পাওয়া যাচ্ছে না। 8/2/2019। ঠিক আছে।
Next to the
Item number 27.
But I appear on the joint receiver, my lord. This is not my application.
check now.
তা 8/2/2019 দেখলেন? তার আগে জাস্টিস ব্যানার্জি
রিলিজ করে দিয়েছিল।
হ্যাঁ, নেক্সট এটা চেক করে নিন আগে। Who is for the petitioner? You are.
No, I am for the joint receiver.
এটা লিস্টে থাকে, লিস্টে থাক।
Item number 28.
Same.
29.
Same. Let it remain in the list. Next.
Item number 30.
Next.
Item number 31. Item number 32.
Yes.
Item number 33. Item number 34. Item number 35. Item number 36.
Within time.
So GA 248 is a restoration application of GA 206. 248, if you could consider restoring. 206 will resuscitate. We can come back for 206 another day.
206 of
Page 21, my lord.
21.
206 of 2020 is the parent application, which gets dismissed for default by an order at page 21.
To be both parties, this matter may appearing. Yes. This is May 20. Once it is restored, then there is no question of again raising any objection. So there is no question of being time being. Oh, January 2024. So there is a delay, no?
Yes. The delay we've explained, we've given the medical certificate also. The delay is
594.
594 days.
Which paragraph you have stated?
Yes, no, your lordship will find that paragraph 4 onwards, we've explained. 3 onward, 3 I've mentioned why I could not appear that day. 4, 5 is there, my medical certificate is added. 6 is why I could not.
Affidavit of service.
Affidavit of service. It was filed on the last occasion, I'm told.
দেখুন এটা কোনো অর্ডার আছে নাকি? No, no, auto notice of motion. When did you file that? If it is filed, then there has to be an order recorded.
That is the copy আছে আপনার কাছে? In GA 248, I am told there were already directions to file affidavits. Orders have also been passed. 4 orders I'm told have been passed.
24?
GA 248, the application that
Which has been
orders have been passed for directing for filing affidavits. No one has come forward. I'm told more than once they were given directions.
Oh.
Order group August. Matter must be the most difficult for your lordship's officers. Because 26 come up together.
You're also not stopping filing application.
That's also true.
এখানে রেকর্ড করুন affidavit. Learned counsel will bring any service, all the copies of the amended applicant has been served, no affidavit. নেই তো এখানে the affidavit of service not filed.
Direction for affidavits have been given and no one has come forward and filed it. Some of the parties are already appearing.
Okay. 248 by defendant number 2, Mr. Sina submits that he wants to file affidavit in opposition. Only defendant number 2A2 was represented by Mr. Sinha, who intended to file affidavit in opposition. Any fine?
No. No one has filed the affidavit.
Okay.
I don't know who the other appearing respondents are today, but at least they don't have an objection to the restoration.
Achha. Chalo. This is an application for restoration of GA GA 206 of 2020.
Just give me a minute. Okay, please, for a majority of the co-sharers, both parties, he's here.
Okay, restoration of GA 206 of 2022. Mr. So learned advocate appearing for the petitioner, applicant submits that due to illness, the applicant could not take steps on the date the matter was called, and the application being GA 206 of 2020 was dismissed for default. He seeks for restoration of GS 206 of 2020 upon condonation of delay. Though liberty was granted to defend number 2A2 to file affidavit in opposition, however, no such affidavit in opposition has been filed. Nahi to Anjan Babu has been filed. Mr. So learned advocate representing majority co-sharers does Ghulam Mustafa does not raise any objection. Considering the amendments made in the application and the submissions advanced on behalf of the applicant, let there be order in terms of prayer. Now, terms of the order dated 5th May 2022 is recalled. The application being GA 206 of 2020 is restored to its original file and number upon condonation of delay. Let there be order in terms of prayer. A. B of the master summons. The application being GA 248 of 2024 stands disposed of.
Yeah. Very good.
Item number 37.
37.
Item number 38.
My application. Look, this is an application for sale of a property, taking it away from somebody who was declared as a successful purchaser, does nothing for over a substantial period of time. Now we've again advertised. We are the special officers before your lordship. We've advertised, somebody has come forward, paid the earnest money or the deposit in terms of the advertisement, and we want the sale confirmation in its favor. I can just take your lordship through that note. The cancellation your lordship will find at page 116.
This copy has been served upon the dependents.
But I haven't checked. I'm told the affidavit of service has been filed.
I have got no objection.
No, my lord. There could be a little more to that. Service collection. Told the affidavit of service is given. From the records, I'll be able to show.
Who made publication? Is there any special officer who will to execute the deed?
I am the special officer. Party receiver.
So where is the publication?
Yes, Lord, I'll just show you lordship two documents at page 116. Kindly see.
আগে affidavit check করে নিন যে সার্ভিসটা কমপ্লিট হয়েছে এটা ডিরেকশন ছিল notice be given to the state has been served state follow you just check and file a affidavit of service huh
We'll serve again, my lord. Direct. This is going to be a contentious matter unnecessarily.
Mr. Spencer Learned advocate appearing for the applicant seeks to serve afresh upon the defendants as well as the state. Let such notice be given to both state and as well as the defendants, and affidavit of service be filed on the returnable date. List this matter in the January, 1 week after vacation.
1 week after.
Item number 39. Item number 40. Item number 41. Item number 42.
Item number 42 to 55, it's my application for addition of party, my lord. In the last occasion, your lordship passed a direction to file the opposition. They have filed their opposition, my lord. My lord, we used to file our replies.
In all the matters, they have filed their opposition.
My lord.
In all the matters, the opposition has been filed.
One opposition has been filed by the defendant number 282.
282.
In 254, GA number 254. Only in one matter, madam.
My lord, in one matter, opposition, here 255.
Which matter you have filed? 254. What about the other?
I have not prepare, my lord. You also kindly. There are 14 matters, my lord.
There are other 13 matters.
One of 14 matters. Well, all are almost similar. Well, you also kindly some time, my lord, so that
From 43 to 42. 42 to 254. You have filed.
yes,
Opposition filed.
opposition filed. They have just now have filed.
Affidavit in opposition 254. Affidavit in opposition filed on behalf of the state, no, joint receivers. No, this is for defend number 2, no? Joint receiver kerosene. Filed on behalf of defend number 2A2 and defend number 12C1.
14C.
Who is Somnath Kundu Chaudhary?
Well, you also kindly take up the my lord, my opposition. My lord, that is the correct cause title I have given.
14C 1 Somnath Kundu Chaudhary. अच्छा डिफेंड नंबर 2 এর নামটা লিখে দিন তো সৌমিত্র কুন্ডু চৌধুরী is taken on record. Mr. So-and-so, learned advocate for the applicant seeks to file affidavit in reply. Let such affidavit in reply be filed within 2 weeks of reopening after winter vacation. List this matter after 2 weeks.
Time for filing opposition be extended.
Which one?
In other 13 matters.
ওটা কি একটা অর্ডার করে দিলে হবে না একটা তাহলে ওটা বলছি একটা সিরিজে করে দিলে হয়ে যাবে হ্যাঁ তাহলে আপনি একটা কাজ করুন 43 থেকে 55 অবধি সেম কজ টাইটেল
I don't know, 43 to 55.
55 Mr. Tapos Kumar Sinha, learned advocate for joint receivers, namely Soumitra Kundu Chaudhary, defendant number 2A2 and defendant number 14C1, Somnath Kundu Chaudhary, seeks extension of time to file affidavit in opposition. Let such affidavit in opposition be filed within 2 weeks of reopening after winter vacation. List this matter after 2 weeks.
I don't know, 56.
Same.
I don't know, 57. Item number 58. Next. Item number 59.
For the applicant, I filed an application for addition of party, your lordship. Your lordship, my senior is engaged in another court. Your lordship, I am praying for a short passment of life.
Next one.
Item number 60.
Let it be in the list.
Late by Mr. Varun Kothari, he's on
Next.
legs in courtroom number 38. I'm praying for not to.
No, this is for which item number?
60.
Your lordship, this is my application.
But he's engaged in.
Readings are complete.
Yes, your lordship, we
Oh.
filed a reply to their opposition.
ठीक है जी लिस्ट था
We are ready for final argument.
Yes, G হচ্ছে 5.
Your lordship,
CS 163. Okay.
Grateful, Your Lordship. 62, 62. Grateful.
much obliged, your lordship.
Item number 61.
নেক্সট আর কেউ আছে নাকি হ্যাঁ ও ওই দেখো সিনিয়র অ্যাডভোকেট এসছেন জেনে নিন কোনো মান্থলি কিছু আছে কিনা হ্যাঁ জেনে নিন জেনে নিন আরো কিছু আছে নাকি কিছু ম্যাটার্স আছে মিস্টার ঘোষাল ও ফার্স্ট কনগ্রাচুলেশনস and 64 তাহলে ডাকুন
Whatever.
that order 7 rule 11
Yes, whatever it is, 64, your lordship, don't allow him to endorse for today.
okay come tomorrow we'll see okay.